that says this meeting's being recorded. Okay, I got that. And I don't know if I'm in control. Am I in control right now?
Yeah,
I didn't have to click anything to accept control.
I did give you a co-host, so just double check on that on your end. But from what I can see, you're good to go.
Okay, so what I'm going to do then, you tell me. I need to share my screen. So let's. There we go. Share screen. And we will share that one.
Perfect.
All right. So just going to ask everyone, is everyone seeing my screen? Good. Okay. Thumbs up from Jennifer. So a couple nods there. I don't see everyone on my, you know how the Zoom works. I don't see everyone right now on my Zoom panel. And you're probably, I'm going to ask everybody to mute themselves out so that you can take phone calls or flush your toilet or whatever it is that you need to do without interrupting the call, and try to minimize some of the echoing that happens from this wonderful technology. But I am going to encourage you, because I've done this hundreds of times, and sometimes I say things and they make perfect sense to me and they make absolutely no sense to you at all, because I'm talking in my brain for the things that I know, and I'm not talking to people who might have heard this for the first time. Sometimes I even accidentally say the wrong word and it doesn't make any darn sense at all. So I encourage you, this is to unclick your mute button at any time you want and say, hey, Steve, it's me, Catherine, or it's me, Amy. And can you please explain that to me again, or ask your question? And it makes me feel like people are actually listening. So, you know, I'll try to screw up intentionally every once in a while to encourage you to engage with me. But we do have 3 hours. We're going to take a break about halfway through. So it's 1 o'clock now. So around 2:30, we're going to stop and take a break for about 15 minutes. During that time, we will leave I strongly recommend that you leave yourself in the meeting. Just turn your camera off or turn your video off and mute yourself and go get your coffee and do what you got to do. And the reason I suggest that is sometimes some people in some of these technologies, when they leave and try to come back in again, we have to accept them back in again, and or there might be some technological glitch. So just stay in there and go do your thing during our break. If I get close to our break and it looks like I'm not, or I'm over my break time, it's because I get so carried away with how exciting this is. Somebody interrupt me and say, hey, buddy, it's 2:30. Let's take a break. And we will. So I encourage you to, even if that's the only time you speak up, to do that for me also. I want to welcome everyone. Again, we've got about 20 people, 19 or 20 people joining us today. 2 from British Columbia, 2 from Alberta, the balance from Ontario. That's pretty typical just because of the way that the world works. I'm going to do something here to try to minimize echo. And so most of the examples that I give today are going to be Ontario-based examples. And it's not because you need to remember what goes on in Ontario and we're ignoring British Columbia. It's just, they're just examples, and understand that there's probably something pretty darn similar in your province in terms of the legislation that we're talking about. And I'm really not asking people today in this particular program to memorize any of the information specifically. So if there's going to be hours of work or maximum time per day or what the holidays are, know that every province is different. And so we're going to be dealing with the concepts here today. We'll be using Ontario and Alberta, and I think maybe British Columbia once in a while for examples. But at the end of the day, in your day-to-day business, you really should look it up for your own province and figure out, how does this thing that we learned today apply to the business that we're operating in? So we want to, first off, I want to congratulate you for signing up for the 2022 CPC Certified Personnel Consultant Program. This is the only certified professional designation that exists for the staffing services industry in Canada. There are a couple other companies out there that have packaged up some modules and some interviewing courses and stuff like that. And they sometimes give them some fancy names, but ACSESS is the only organization in Canada offering a recognized certified program for the staffing services industry. And our certification program, I can't even tell you how many years it's been around, but 20 or more years ago, ACSESS, which previously was called the Federation of Temporary Help Services, and APAC, two associations, the Association of Placement Professionals and Consultants, merged together to create ACSESS. And one of our mandates was to create a certification program that was great for search consultants, permanent placement consultants, contract agencies, and temporary help services, temporary staffing services, and to bring them all together and to create some certification and training for the industry. We tend to not get into real proprietary training like what to say in a sales call, but we deal with some of these things, the legal aspects of staffing, health and safety, the legal aspects of recruitment. So we're dealing with high-level legislation issues. We deal with recruitment and selection. Of course, there are a ton of recruitment and selection tools and so on. We don't drill into whether Bullhorn's better than something else or whatever, but we do drill into all of the technology and why they're beneficial and things you want to look for, the features and benefits of various recruitment and selection tools and methodologies. And of course, my favorite, business practices and ethics, because most people want to join ACSESS, the association, because specifically of business practices and ethics, and they want to separate themselves into the group that seems to care about that the most for their business model. At the end of taking these 5 courses, there is what we call the CPC challenge exam. And again, I want to remind you that you're not going to be asked when it comes to the exam to memorize very detailed aspects of your particular province's legislation. You're going to be asked about concepts. What are some of the legislations that are concerned about human rights? That kind of thing. And then if the Manitoba human rights legislation has certain things that are covered or worded differently than Ontario or Quebec, don't sweat it. The exam is going to be talking about high-level concepts so that you know that these things exist, what principles they cover, and where to find the details for your specific province. Now, in order to take a CPC, you need to be belong to an ACSESS member company. So your company, whether you're the owner or working on a desk, sorry, I forgot to turn that phone off. Whether you're the owner of the company or a manager, or you're working on a desk or in administration, you're only really permitted to sign up to take these courses and to become a certified personnel consultant if you are a member of an ACSESS company. Once you've achieved your CPC, then it is yours forever. So if you retire or if you move employment and you go to a company that's not an ACSESS member, you still keep your CPC designation for life. And so that doesn't change, but the only people that have access to this proprietary training are members of the association. So you're not a member of the association as an individual, you are a member of the association as an individual who is employed by an ACSESS member. So companies join and their employees have access to all the features and benefits that are associated with ACSESS as an organization. So I'm going to say this was, these are sort of some high level things that I probably will say in every course that you take from me, but you can go to the ACSESS website, ACSESS, ACSESS.org, and you can create a member user account. It has to be approved. You might have to send an email to Jennifer and say, hey, can you set up my membership for me? But once you've got that set up, then you can have access to training materials and schedules of events and all kinds of things that are going on. there. So I am going to encourage you, if you're not already using the ACSESS website for resources, then please go ahead and do that. The ACSESS mission statement that your company has committed to is to identify, communicate, and monitor industry standards and ethics and business practices. And so that's, I already mentioned that the ethics is usually one of the first reasons why, and industry standards and practices are one of the first reasons why companies join us. But the other reason is to positively influence and protect our industry from the regulatory environment. We know, and I'm going to talk about some new legislation coming down the pipe today, that there are legislation that specifically affects our industry, and very often a little less today than, say, 5 or 10 or 15 or 20 years ago. But particularly when it comes to labor and employment legislation, civil servants and bureaucrats, when they sit together, they think about traditional employment. They're thinking about that person who works for a company on a full-time or a part-time basis, and they're like working directly for one of our client companies, and they're trying to develop legislation that will protect the interests of employers over employees in those types of relationships. And it became very apparent many years ago that the third-party relationships and the nature of our industry in temporary and contract staffing, really very often the legislation was not applicable, didn't work well, and really often was worded really improperly to take into consideration these kind of relationships. And so we are always at the table with the regulatory folks, provincially, federally, and sometimes municipally. And also we're at the table with federal and provincial governments with respect to tenders. You know, all of these standing offers that set up with federal government and bids that you can apply on, you know, there's a pretty darn good chance that those models for tendering were based upon our relationships and negotiations with the government on setting those up so that they were worded appropriately for the temporary and recruitment services industry. We want to promote the credibility and visibility of the industry. And so when we all look good, when we're conducting ourselves in a highly visible manner, we're doing it with a high level of integrity and ethics, then companies want to do business with us, and candidates want to use us to try to find their employment. And we provide our members with strategic support services and tools, and you can find that through the ACSESS website, very often in forms of brochures and training and guidance, guidelines. So those are the kinds of things that we want to offer to people. So this ACSESS Code of Ethics and Standards, when a company joins ACSESS, they make a commitment to uphold the industry's Code of Ethics and Standards. And so there is usually a poster or a posting on the company's website and in their office or in all of their offices that is the ACSESS Code of Members, Code of Ethics. And let's go on and figure out what we're going to talk about today. Oh, by the way, if you don't have that Code of Ethics in your office, or if it's not on your website, you can always reach out to Jennifer in the ACSESS office, say, hey, can you send us a copy of that? Or can you give us something that we can print out and put in a frame and put in our offices? But when you do become a member company, the original certificate and Code of Ethics and Standards is mailed out to your company. We move, times change, but it's always a good idea to have those things posted in a very prominent and visible way. So today we're going to talk about, I'm going to move this little, you might have it too, little box on the right-hand side that's showing me some of your handsome and beautiful faces out of the way so I can see what's on my screen. We're going to learn today about employment standards legislation and the difference between provincial and federal legislation and what's included in that. We're going to talk about this concept of employee co-employment and contractor status and the differences, particularly with liability issues for temporary help agencies, independent contractors, and so on. So we'll talk a little bit about that. We're going to also explain some of the applicable sections of the Employment Standards Acts that either one, like in the case of Ontario, sometimes in Quebec, where they name our industry specifically. So there are specific aspects of the code that deal with temporary help services or temporary staffing services and employment agencies. And in some provinces, it's implied and interpreted, and there's case law around it. So we're going to talk about some of those things. And we're going to talk a little bit about how we use this legislation to make our commitment to operate our companies legally and ethically and profitably as a result of knowing some of this stuff. So talk for 3 hours straight. You got to take a sip. In my life, there's never enough coffee. You know, when we're in the room together and we're chatting and I can see people writing things down, we have a lot more conversation. So I'm pretending like you're having a conversation with me. It's really lonely. But, you know, typically when we do that, we have a little sort of discussion about, hey, who's taken human rights courses before? Who's done this before? So you got to kind of rate yourself here. And you have to ask yourself, have you studied any of this stuff before? If you haven't studied it, maybe you should. There's courses available online. There's courses available through organizations like ACSESS. Of course, you're doing it right now. There are webinars and things offered through employment groups, through workers' compensation board and other safety associations. You can take it at community colleges and university, but have you studied the Employment Standards Act before? Are you available? Do you have the resources available to you? So pretty much every province has got a whole bunch of posters and brochures that are supposed to be available to all your applicants and people coming into your office. And they're pre-printed or they're available to download. So usually your provincial and Ministry of Labor, we're going to go over the various names in the different provinces because they're called different things, different provinces, but usually they have those resources available to you. We want to ask whether or not, or you might ask yourself whether you're comfortable managing temporary employees with respect to the risks that exist because of the employment contracts and employment arrangements and the things you ask them to do and the way that you treat them. And are you comfortable with your customers in terms of them asking you to do things that you might wonder, boy, are they really allowed to do that? So are you comfortable in managing these things? And then, you know, we're going to deal with some action items like, do you consult with your customers and with your employees regularly? And do you try to help them to understand what their obligations are? And how do you use this to help further your business and to protect your business? Why is it so important to know the law? Again, this is supposed to be a poll. Oops, I'm going to go backwards. I clicked too soon. Knowledge will help us to educate our customers and to reduce their risks. Sometimes customers unknowingly, unwittingly, sometimes intentionally ask us to do their dirty work, but sometimes they ask us to do things unknowingly or unwittingly that are not permitted in law. We want to protect our employees to ensure that they receive their minimum entitlements. We want to improve productivity by eliminating misunderstandings and problems. So, you know, I've got this thing called Steve's rules. And when I'm doing consulting with people, there's 54 of Steve's rules, and they're all pretty kind of high level. But, you know, one of the rules says that most problems that exist in business come from poor communication. And I think the next rule says that most problems are resolved in business by improving communication. So, you know, a lot of times we have some issues and misunderstandings and problems because people go ahead doing things that they ought not to do or shouldn't be doing, or maybe misunderstand it, or maybe were never told what some of the standards were with respect to legislative requirements and contractual requirements. And so we want to try to eliminate those misunderstandings and problems. We want to promote your personal professional reputation and limit your personal and your company's liabilities. We want to protect your company's reputation also in going forward. So when we sometimes do things, we've got questions on our application forms or things we put in our job postings online, you know, if they're not appropriate, sometimes people don't know how to word them or how to present them in such a way that will continue to protect our professional reputations. We want to earn respect and dedication from our clients. The best client is a repeat client. The best clients who give you the most amount of business are those companies that give you repeat orders, whether they're perm, search, you know, contracts, technical, light industrial, temp, it doesn't really matter. The best customers we have are those ones that give us repeat business. And so we want to earn their respect and dedication, because they can look to us for good advice and for things to be done properly. And sometimes when they don't know, they don't know who to call. They can call their lawyer for $750 an hour and hopefully get on a simple answer to a question around employment standards, say, for example, the same exact answer from you, which will save them the $750 and will enhance your relationship with them on the business side. We want to differentiate your company from those in the marketplace that don't know. We want you to be able to use your ACSESS membership, your knowledge, your ability to consult, the way that you present yourself in the marketplace. We want you to be able to differentiate yourself. And so I encourage you that when you get your CPC, when you get your next set of business cards, to put that CPC behind your name with your other PhDs and BAs and HBAs and other things that, CHRPs that you might have there. I want you to make sure that you put your CPC there also, and don't be afraid to tell people that you are a certified personnel consultant. We want you to be able to retain your workforce. Boy, what shortage of candidates in the marketplace. You know that, I don't need to tell you. It's always been the case, but it's probably more pronounced now than it's ever been in my years in the business. And before we go on to the next slide, I'm going to tell you my years in the business, so that if I tell you some things today that, you think, boy, that's hard to believe. Is that true? I'm going to give you a little bit of background about me so that you can understand that it's coming from a place of experience and knowledge. But you want to be able to retain your workforce, and candidates that you can keep in your pool, workers that you can keep in your pool and continue to use. It is thousands of dollars less expensive and highly more productive. You tend to get higher satisfied customers to keep the same candidates, especially if you're in the temporary help or contract business, working for you for years and years and years, than for every time you get an assignment to have to go out and try somebody new. So finding a person, evaluating them, guessing after you've done everything. Have I done everything right? And is this person really as good as they look? Then taking a chance and they do a no-show, or they don't show up, or they piddle on your customer's floor. These are the kind of things that don't happen when you can retain your workforce and continue to use and employ and maintain a relationship with the same people. So there's nothing that causes you to lose your employees more than to have them feel like they're being treated unfairly, improperly, or illegally as you deal with them. And so you want to make sure you get it done right. And of course, we want to adhere to the ACSESS Code of Ethics and Standards, because we have said we would do that. Okay, so just a little background. We didn't do this at the beginning, but I joined this industry in 1983 with a small independent company. There were 3 or 4 of us that worked in the company. 3 of them left and went off to start their own firms and did really well and became very successful. And I was the new kid, with plastic briefcase and polyester pants, trying to, figure out how to learn the business. And our owner, who was really an investor, entrusted me to try to figure out how to grow the business. We grew the business from that one single office with 3 or 4 employees, and eventually just me standing, to about a $400 million a year staffing business. We had over 7,000 contractors and temporary workers working for us a day, filled over 24,000. In the year that I sold the company, over 24,000 jobs were filled that year by our company. 9 years ago, I sold the company and thought I was going to retire for personal reasons. I had a sick family member that I wanted to take care of, and I thought, what the heck? This is why I tried to be successful, to take care of my family. And so I sold the business. We were so blessed. She's alive today, and we got through that crisis. And I went back into the business in a different way as a consultant, working with ACSESS and hundreds of staffing companies and non-staffing companies across Canada, United States, helping them with their strategic planning and their business modeling and so on. We have a profiling tool that we use to help organizations, and we've done thousands and thousands, probably about 4,000 assessments of recruiters and consultants for the staffing services industry in Canada, United States. So we kind of do that. And I also bought and now own 10 franchise territories in a home healthcare business. And so we've got about 450 caregivers and about 350 nurses, and we deal with 12 hospitals, supplying them with their replacement nurses and caregivers. So I'm still, and the home care industry doesn't believe me, but it's just a specialty staffing industry. They like to call themselves something different, and everybody comes from medical backgrounds or whatever. But the reason why I'm the largest franchisee in our franchise business is because I treat our home care business like a staffing service, and we utilize all the same tools, knowledge, experience, recruitment talents to help grow the business. And although I don't work in that every single day, I own it and operate it, and I am president of the company. So I'm still kind of, in the staffing business specifically. So, and over all that time, over those many years since 1983, I've served about 9 years as ACSESS president, and I've chaired government and public relations and made hundreds of trips to Ottawa and Queen's Park and other places on behalf of the industry to help develop some of these legislations. So I'm an old dog. I've forgotten a lot. But you're always welcome to send me an email, call me, and ask me a question. And when this is over today, if you feel like I didn't explain something well, or you want some questions, feel free to reach out to me. It's part of what I offer in offering these programs. So I'm very glad to give you some guidance on some clarity on the things we talk about today. Okay, enough about me. So we're going to talk today about 4 levels of law and how they apply. And we're going to start off with, and I'm not going to go into the Constitution and the Charter of Rights and Freedoms, but I'm going to describe it like this. So this is the dummies' understanding of the Canadian Constitution. I'm the dummy, not you. This is the dummies' understanding of the Canadian Constitution and the Charter of Rights and Freedoms. These laws are the law of laws. This is the set of laws that helps us establish what other parameters all other laws must fall within. So it's not a law that says thou shalt not drive this fast, or you're allowed to do this. You're allowed to, ask these kind of questions in an interview. Constitutional law lays out the parameters that all other laws, including contract laws, must abide by. So when somebody says, well, that statute or that law that the government's trying to pass is unconstitutional, what they mean is that the government's trying to implement a law or a statute that doesn't adhere to the law of laws. It doesn't adhere to the Charter of Rights and Freedoms or to the Constitution. So the Constitution will lay out who's allowed to make what laws over what kind of stuff, and the Charter of Rights and Freedoms gives us parameters about what those laws are allowed to cover or not allowed to cover, and what kind of restrictions, limitations, and privacy issues they're allowed to intervene into or not allowed to intervene in. But the Constitution is not like statutes where it drills down deep to tell you that you're allowed to drive 60 or 100 or 120 kilometers an hour. It says that it tells you who's allowed to make that law. That's the Constitution, deciding who has authority over various jurisdictions. And it tells you what standards those laws must uphold or live by. Now, we have statute law, which are the kinds of laws that are passed in legislatures. They're either federal statutes or provincial statutes. So they're done in the legislature or the House of Commons. And these are the laws that are elected members of parliament put forward, and they vote on, and they go through first, second, third, fourth reading, and they go through a process to come into law. And then, of course, we have got common law. Now, common law is the sort of law that's been decided by the courts. So if there hasn't been a specific statute that specifically says, so let's go back for a moment. A lot of times when we hear the term common law, we hear, oh, they're married in common law. That's a common law marriage. Okay, so what does that mean? That means that there's a bunch of statutes out there provincially that says who's allowed to hold a marriage ceremony and who's allowed to who's authorized to give it a marriage certificate, and what there's a various bunch of legislation federally and provincially about what kind of tax breaks you get when you're married, and all that kind of stuff, and whether you can pass RSPs back and forth. These are all written into statute. But some people just lived together and they acted like they were married. They shared the same house. They had kids together. And so eventually the courts came along and said, well, geez, even though you didn't go stand before a judge or go into the church or get a justice of the peace or someone who is certified to marry you, for all intents and purposes, you're married. And so they said, we're going to have these known in common standards that become laws. And so this becomes common law. So the other thing that happens in common law that is more applicable example for us is the common law that have existed in court cases arising from people quitting or get fired from their jobs. And so when people go and sue their employer for, say, constructive dismissal, or when people try to figure out how much do I get from my employer, how much should they give me if they fire me for no reason whatsoever? Well, first off, a judge is going to take a look at that bottom thing there, and they're going to say, well, do you have a contract? Because if you have a contract, I don't have to rely upon common law. If you've got a contract, you guys already agreed upon this. But in the absence of a contract that is legal, that has passed all the tests to be a legitimate contract, we can go back to, you've heard the word before, case precedent. So these are the decisions that have been made by courts in the past that have established what the laws we all should share in common. Because once something is decided in court based upon a set of circumstances, when those circumstances exist exactly the same again in the future, all courts should come to the same decision. And this pattern of decisions that are made by courts becomes the laws we share in common. So this is common law. And then, of course, we have contract law, and contract law are things like a prenuptial agreement before you get married, and the employment contract that you have with your employer, and the contract that your company has with your customer to provide services and make payment for services. And so we've got all kinds of different, and some say that when you walk into a store, you sign you're operating under a contract. When they put the price up there, they're contractually obligated to sell you for, that item for that price. And so we start to package together some combination of the written contracts with common law, and those become the laws that we operate under. So a really well-written contract usually is really long because it's trying to cover off all the things that could happen. And in the absence of things that are not anticipated or covered in the contract, we would refer upon to common law. So here we have constitutional law, the law of laws, the laws that tell us who's allowed to make a law and what kind of standards they have to uphold when making those laws. And then we've got statute law, which are made by cities about whether or not you're allowed to walk your dog in that park. They're made by provinces about how fast you can drive and what certain things should be covered under the Employment Standards Act. And then we've got the federal government that will determine whether you're allowed to cross a border without a vaccine certificate or not. These are federal laws. And then we've got common law. This is the set of laws of decisions from case precedent that we now all share in common because these things have been decided by judges before. And then we've got contract law, which are the agreements that we write between two parties to behave in such a way and pay each other and obligations we make towards each other. So we've got contract law. So today I'm going to bounce back and forth between statutes, common law, contract law, and hopefully I don't confuse the living bejeebus out of you if I am moving between different types of laws. So the first thing that this Canadian Constitution does is it says who's responsible for certain stuff. And we know that the provinces, say, for example, are responsible for education and healthcare, and they're responsible for employment legislation for all provincially regulated industries, and that the federal government is responsible for certain things that are designated in the Constitution, and also responsible for the federal labor code. In other words, the rules that apply in employment and in unionization for federally regulated employees. So that would be all employees of the federal government and all industries that are regulated by the federal government under the Constitution. And so very often the provinces, the Employment Standards Act in Ontario, the Alberta Labor Code, I think it's called the Alberta Labor Code in Alberta, the Federal Labor Code or the Canada Labor Code is the set of laws that applies to the federal government and all federally regulated industries for their employees. And each province has its own Employment Standards Act or Norme de Travail in Quebec or whatever it's called in each province for the rest of us who are employed by companies that are covered underneath the provincial legislation. So you'll see here some of the different names. It looks like I've stuck these things on the page to represent the province. So I think in British Columbia, it's called the Employment Standards Act. It's called the Employment Standards Code and Regulation. In Ontario, it's called Employment Standards Act. In Quebec, it's called La Norme de Travail, the Travail work codes, work norms, loose translation. So we've got the Federal Labor Code. And then so you ask, okay, so what are the industries that are federally regulated that fall under the Canada Labor Code? And they are banks, airlines, interprovincial railways, and trucking companies. If you've got a canal or a pipeline that goes intra-provincially across many provinces, so you can have a pipeline that only goes from Brampton to Toronto, that would be provincially regulated. But if it as soon as it crosses a province, then that pipeline becomes provincially or federally regulated. So things like the CRTC, the Canadian Radio and Television Communications Commission, is federally regulated. So the issuance of radio station licenses and telecommunication licenses, these are all covered by the federal government. So you get a sense from looking at that list, which is not entirely, but it gives you a pretty good sense. You get a sense, uranium mining is covered by the federal government because it's so darn dangerous that if you were to dig it up close to the border, it would probably kill the people on the other side of the border. So, if you dig it up improperly. So certain things, you get the sense that those things that can't be defined by the provincial borders tend to fall under federal labor code, and those things that clearly can be. So if you're in employment of the federal government, and it doesn't matter what province you work in, you fall under this code. If you get board an airplane that crosses the borders, of course, it falls under the federal labor code. So the most recent thing is this trucking thing and mandate certificates. Every province has got different rules about certificates and mandates and, barcodes and vaccine stuff. And the federal government only has control over going across the borders into United States or getting on a plane to fly to a different country. They have no say in whether or not you should have a vaccine certificate to drive around in Alberta. That's totally up to the Alberta government to decide. So you can see that some of these things are pretty obvious about who should be in control. These are all defined in the Canadian Constitution and were originally defined in the BNA Act, the British North American Act, which was our original constitution, which was modified in 1984 to become the Charter of Rights and Freedoms and the Canadian Constitution. You're going to hear some terms every once in a while that will now, maybe it already did now, make a little bit more sense. So when you go to have a public holiday and the schools are closed and things are closed in your province, sometimes the banks are open. Sometimes, like, for example, on Remembrance Day. Now, remember, Albertans, Remembrance Day is provincial holiday in Alberta, but it's also a federal holiday under the Canada Labor Code for federally regulated employees. So the federal government's shut down on Remembrance Day, but the Ontario government is open because the Ontario government has its public holidays. Remembrance Day is not one of them. So in Ontario, we often use the expression, oh, it's a bank holiday. So your kids go to school and 11 o'clock in the morning, they stop and have a minute of silence for Remembrance Day celebrations, and they maybe talk and learn about Remembrance Day that day. But their dad, who works for the bank, is at home, and their mom, who works for I don't know, the brokerage house, which is provincially regulated, is at work because mom is a stockbroker who works for a provincially regulated company. Dad works for the federal government or a bank. It's a federal government holiday, so he's at home. The kids are going to school because education is provincially regulated. So schools are open. It's not a provincial holiday. And so very often in provinces where businesses are closed because there's a federal holiday, but the residents are going to work because we're provincially regulated or going to school, we call it a bank holiday. Oh, it's a bank holiday. The banks are closed today. So that's where that expression bank holiday comes from. It's not a real term. It just means banks are federally regulated because they go across all the provinces. And as a result of that, when the federal government introduces a public holiday for federally regulated businesses, banks are closed. So we call it a bank holiday. So we want to know basically what jurisdictional issues exist for us. Temporary TSAs, by the way, is the new, in probably the last 5 years, you start to see legislation pop up and people in government referring to temporary staffing agencies as TSAs, temporary staffing agencies. Temporary staffing agencies and employment agencies are provincially regulated, like probably 90% of our customers are, unless you're doing business with banks, railways, or the federal government or airlines. So most of our customers are provincially regulated. TSAs, temporary staffing services, and employment agencies are provincially regulated. So we need to know our jurisdiction, because what happens, say, for example, if we're supplying temps to the federal government and they've got a holiday, but we're open. Do we pay public holiday pay to the worker because the government's closed? I'm going to talk about that later on. The answer is no, because we're our employee, not the government's employee. Just because our customers shut down that day doesn't mean our employers are entitled to the benefits that our customers get. And when we're shut down, the government might be open. So we need to give them public holiday on those days and vice versa. So we need to know the applicable laws. We need to know the employee's workplace or assignment location or province they work in. So if we're an Ontario-based company under Ontario law, but we send them across the border to work at Place de Portage in Hull, Quebec, and it doesn't matter whether the employee lives in Quebec or whether the employee lives in Ontario. It doesn't matter whether the customer is provincially regulated customer or federally regulated customer. It doesn't matter whether the customer's office location where the assignment is in Quebec or in Ontario. None of that matters. What matters is, where is the company located? What province is it legislated under? Is the employee an employee of that company? Not who's the customer, not where's the assignment, not where the employee lives. What matters is that they're an employee-employer relationship. What province is the company legislated under? And what laws apply to that company for its employees? Make sense? Nod your heads. Good. Excellent. All right. See, this is what we call good communication. Okay, so we need to kind of understand these things a little bit all the time. We also need to understand the difference between an employee versus an independent contractor. Now, I could give you a whole hour, 2-hour presentation on the 7 conditions of determining an independent contractor, on balance, how these conditions exist, what you do to mitigate your damages in the case you've inappropriately classified for. Let's just say this. almost everybody starts off as an employee, or starts off being, I should say this, almost everybody starts off being assumed that they're going to be an employee, unless the conditions exist to be an independent contractor. So first off, don't assume that they're going to be an independent contractor. They are an independent contractor, and we'll just take that for granted, because most legislation in this country and most governments, whether it's a workers' compensation issue or an employment standards issue or an unemployment insurance issue or a Canada pension plan issue or a human rights issue, most legislation will say, hey, they're an employee, and it will be your responsibility to prove that they're not. They'll just default to be an employee, an employer-employer relationship, and they will just, it's your responsibility as the person who's paying them to decide whether or not they are an independent contractor and to prove that they are. So understanding not only that you need to have a contract that makes all those definitions, you also must understand what common law determinations exist, because your contract probably isn't going to envision every single thing that could possibly ever happen in the world under every piece of legislation. So your contract needs to be extremely well written, because in the absence of the wording, it's going to fall back on common law. And you have to understand that there's some legislation, like in Ontario, that says that they are your employee. They're not your customer's employee. So we need to understand how these things work, how to protect ourselves, how to create the definitions. And we could talk about this beside the water cooler if we were all in the same room, but we're not in the same room. So let's just pretend we did. Okay, so let's talk about some things that have to do with minimum standards. These are examples. Most provincial employment standards acts or labor codes will have these types of things in them. Sometimes they're worded a little bit differently. Sometimes they're bundled together, but most employment standards acts have a requirement that companies have available information to their employees and to their job candidates so that they can be well informed. So they provide you with posters and other things that must be visibly available to candidates and employees, posters and brochures. Most employment standards act covers hours of work. So how many hours a day, how many hours a week, how much time in between shifts, are maximums, are there minimums? Do people get paid lunch or unpaid lunch? Do they get rest periods? These are all covered under Employment Standards Act. We've got payment of wages. So not just minimum wage, like how much should be paid, but how it should be paid and how it should be documented. So things like having pay stubs or having a place that they can go online to look up their wages. If you're paying people cash and you don't tell them how it's calculated, and you don't give them a record to show them how it's calculated, that's against the law in most provinces, in all provinces. Overtime pay is defined by Employment Standards Act. When is it due, after how many hours, and how do you calculate it? Types of pay, including tips and gratuities and overtime pay and vacation pay, those are all defined in Employment Standards Act. One of the more controversial and often discussed things that are put into employment standards acts or labor legislation is minimum wage. So we'll talk a little bit about that. I've got a screen on minimum wage, or a couple screens later on. So things like leaves. Now, Ontario went crazy. I'm not saying they did it wrong, but I mean, they just went crazy in terms of how they worded it during the liberal, I guess it was Kathleen Wynne's reign of power, introduced a ton of different kinds of leaves. And she did that leading up to their last lost election, thinking that if we give everybody all these things that they'll vote for us, and many of these things remained in place. The Conservative government, they're not on this list, but the Conservative government, when they got into power, repealed a number of those things. So they actually never really happened. But like a lot of governments do, they make a bunch of promises right before an election. Then they got to go into the legislature and they have to pass the law. But then there's a waiting period before it comes in. And sometimes those things don't come in until after the election's over. Sometimes they do come in, but then the government just comes in and passes the law right away to reverse it. So this is what happened. There was just a ton of different kinds of leaves. And so they redefined pregnancy leaves, personal emergency leaves, family caregiver leaves, family medical leaves, critical illness leaves, child disappearance leaves, child death leaves. And then, of course, they introduced, the both mother and father for pregnancy leaves, and they introduced all kinds of different kinds of ways that people could apply for that, which, by the way, is totally different than whether or not, say, for example, you qualify federally for unemployment insurance while you're on maternity leave. So the federal government, who covers unemployment insurance, which is a federal program and federally legislated, sets certain standards for who and how you qualify to get unemployment insurance. The province decides how long you're entitled to take off work without putting your work employment in jeopardy. So you're allowed to get the same or a fundamentally similar job back again. So they tell you how long you can be off for, and sometimes with pay and sometimes without pay. And so they define those things in the legislation. The provincial governments define when public holidays are. I already talked about this ad nauseum. The federal government decides when federal government regulated employees get their public holidays: Christmas Day, Boxing Day, New Year's Day, Family Day. In Ontario, Christmas Day, Boxing Day, New Year's Day, February Family Day, Good Friday, Victoria Day, Canada Day. There's a weird holiday, the 1st of August in Ontario, which is not covered under the legislation, but it's a weird one called the Civic Holiday. Labor Day. What am I missing?
Thanksgiving
Day. Oh, thank you very much. Yep, Thanksgiving Day, the last holiday before Christmas. So thank you very much for that. And unmuting yourself. We have got interaction. But those holidays aren't exactly the same holidays in every province. So know your province's public holidays and the rules around them. It also covers hours of work, breaks, termination pay, how much people are entitled to if they get fired for no apparent reason, for no reason of cause. We're going to talk a little bit today about severance pay and termination pay, how in Ontario and different provinces, those terms differ from each other: termination pay and severance pay. There's equal pay for equal work, which has to do with gender. And there's also, in all of these laws, rules about what the penalties are if you break them, how to appeal them or how to launch a complaint for them, and what the penalties are if you are what are called reprisals, if you punish people for using the law because they think they're covered for it. So if a person thinks, geez, that's not minimum wage, and you say, geez, shut up. If you don't take these $4 an hour, I'll fire you and never employ you again. Well, that's called a reprisal. So there's even laws written in the Employment Standards Act that penalize companies for reprising against people who are standing up for their rights. If you use the law to protect you, and then somebody says, hey, you try to use the law to protect yourself, but I'm going to punish you for that, there's more punishment for that punishment. It's called a reprisal. So these minimum wages, here's the most recent minimum wages from January 2020. And as you can see, they're not really that high. And some of the provinces are dragging their feet, like New Brunswick at $11.75 an hour. So you wonder why a whole bunch of university graduates and are not moving to New Brunswick, because they're trying to pay people $11.75 an hour there. But hey, listen, I've operated in every one of these provinces and territories offices. And, even though Manitoba has got a very low minimum wage, we've never paid people anything close to minimum wage. So sometimes minimum wage can have a significant impact. And sometimes it can be so widely disregarded that people are paying so much more than minimum wage that who cares? Like, it doesn't really matter. Why would you worry about that kind of thing? Because if you're paying people for 15, 16, $30 an hour in Manitoba, does changing minimum wage have any effect? So how are minimum wages decided? Well, there's two ways in general. One is that it's passed through legislation, that the government in power provincially goes into the legislature and they introduce a amendment to their Employment Standards Act. So they're going to amend the clauses that deal with minimum wage. So they're going to increase it. And also, sometimes they pass legislation that sets out some time and rules for when future minimum wages will be increased. So, for example, the Ontario government during the Liberal years went in and passed law that said, here's what we're going to do. We're going to increase it by $1 an hour. And then every year for the next 5 years, we're going to increase it by another $1 an hour. And so they passed one piece of legislation that had scheduled changes to take place in the future. Other provinces, Manitoba at one point, not Manitoba, Alberta at one point in time, tied together their minimum wage to the inflation rate. So they said every year in the month of March, we will review. I don't think that law exists anymore either, but they would say every year in the month of March, we will review the inflation in the 12 months previous in the previous year, and that the minimum wage will be exactly that percentage, and rounded to the nearest 5 cents or something. And so you can have it specifically done one off. You can wait every 5 years and a new government can come in, maybe run an election based on the fact they're going to increase minimum wage, or they can have scheduled changes based upon a formula or scheduled changes based upon an amount, but they do require to be passed in the provincial legislature, or if it's a federally regulated industry, minimum wage by the House of Commons. How often? Well, they're updated whenever the government feels it's appropriate. So lots of advocacy groups put pressure on the government to try to increase minimum wage frequently, and other advocacy groups don't want it to be increased. So it typically becomes a political decision, usually not an economic decision, and it's done at the political will of the government. So what are the implications of higher or lower minimum wage? I'm not going to go into a ton of detail on this. It's very opinionated. There have been a gajillion studies, really hard to get what's called ceteris paribus, all things remaining the same. So you typically, introduce a minimum wage change, but there becomes a shortage of people in the workforce, or there becomes a lower economy in a recession. They really have never been able to say absolutely increasing minimum wage has these benefits or has these harms, but there's some pretty general understandings that when you increase minimum wage, it has a trickle effect through other jobs. So if you have got 4 people work for your company, this one makes a minimum wage, this one makes $1 more, this one makes $1 more and $1 more. If you increase this person by $1, you probably have to increase everybody by $1. So minimum wage has typically people believe has a general ripple effect through most job classifications. Of course, it doesn't typically affect a sales rep who works off commission or things like that, but as a typical general effect, people believe that it affects inflation, that if you increase minimum wage by a certain amount, it increases costs and that there's inflation. But there's lots of studies that show that economies have done much better by increasing minimum wage, that the higher you pay somebody, the more higher quality work is done, and there's retention of employees in the job workforce, and that there's less turnover and there's less people suffering, from starvation, and that it has a general positive effect. So there's arguments both ways. The implications sometimes are obvious, sometimes are very nuanced, and different people with different beliefs and different circumstances will have different opinions about that. Now, for those people who are in the temporary staff, this is part of the business, which I think maybe lots of you are. And for those people who are in the contract side of the business, I'm just going to say this one thing. If you've got a pretty good handle on your margins and markups, And particularly if you're in a agreement with your customers that are based upon margins and markups, then the more you pay people, the more money you make. Because if you pay somebody $10 an hour and mark it up 50%, you've got a $5 an hour gross profit. And then, of course, you have to subtract all your costs and vacation pay and unemployment insurance. And it might turn out to be 33% by the time it's all said and done. But if you pay somebody $20 an hour, then you mark it up 50%, you got a $10 markup. Now, what would you rather have? A $5 markup or a $10 markup? I think at the end of the day, you make more money when you have a $10 markup. And so, you might say, oh yeah, but it costs us more money and it ties up more money. Money is free these days. I mean, you can borrow money for like 1 or 2%. You don't need to worry, so much about those things. Like there's a shortage of money in the world and it's going to cost $1 gajillion to get money to pay these people $20 an hour. Reality is, if you pay an engineer or a contractor, an IT professional $40 an hour and you mark it up by 50%, you make 20. And if you pay them $100 an hour and you mark it up 50%, you make 50. And I don't know what you'd rather make, 20 or 50, but I'd rather make 50. So pay in our industry, people will criticize our industry and they will say oh, this exploitive industry taking advantage of people, underpaying them, paying them minimum wage. And they gotta, say, hey, dude, the more money they make, the more money I make. So I want to pay people more money. I just do. It reduces my turnover. It reduces my recruitment costs. And for those people in the recruitment industry, charging fee for service when you're doing permanent placements and executive search. I mean, really, if you've got the exact job description on 2 job orders and one pays $100,000 a year and one pays $50,000 a year, they're both in the same city, in the same place, in the same industry. Exactly. Which one is easier to fill? The one that pays more money or the one that pays less money? So you can fill a whole bunch of the jobs that pay $100,000 a year, and you can fill none of them that pay $50,000 a year and work all year long and make no income. So, this whole notion that, we love minimum wage and we like to pay people less money, it really doesn't fly with me. I personally have always been more successful by paying people more money in this industry. And so, does minimum wage change by age or industry? And the answer to that is simply yes. And every province is different. But there are people that work in the hospitality industry, restaurants, and who get tips. There's a different minimum wage in some provinces for that. Students who are under the age of 18, there's a different wage sometimes for that. Other more specified industries, like in Ontario, they increase the minimum wage for healthcare workers and so on, or they tried to. And so there are differences. Just know them and look them up. But generally, minimum wage is minimum wage. So for payroll requirements, how are we doing for time here, guys? Okay, 25 minutes before our next first break. So we need to have a payroll period. You can't make up your mind at will when you're going to pay people. If you're going to use direct deposit, you must have deposit the money in the name of the person. You can't have somebody deposit the name of their spouse or their kid or their mother. It has to be into the name of the person who actually worked for you. There must be the stub. We refer to it in the legislation as the stub, but these are wage statements. So they either have to come on the piece of paper that comes with the check, or they have to go, electronically to them in their email, or they have to be someplace where they can go in and look it up, get access to a secure system to look it up. There are certain deductions that have to be made, unemployment insurance, Canada pension plan, tax, taken off of a person's check. These are all statutory or written into the law, but you can also have court orders. So a person can have their wages garnished by a court order, and you have to abide by those court orders to withhold things and remit them from a person's check. Other than that, don't be taking stuff off people's checks. There's statutory deductions. I talked about those, CPP, UIC. And then vacation pay must be in all provinces, must be separately calculated and separated on their pay statement so that they know how they got their vacation pay. So they could maybe get accrued vacation pay. So they work $1,000, make $1,000, and they got $40 that is accrued and put in the account for them to be taken later, or they could get 4% vacation pay. So on each check. And so you pay them $1,000 and pay them $40 on that check. It has to be separately itemized on their check so that they know what they have and how it's calculated, what they have in their accrual account to be taken later, or how it was calculated if they received it today. And of course, it's taxable and so on and so forth. So in order to have other payroll deductions like uniforms and things, you must have written authorization in advance. It's not something you can do after the fact. If people don't approve it in advance, you can't take money off. I personally recommend people don't take money off people's checks, that unless they've, like say for instance, an RRSP, and they sign a document and say, hey, will you take off $50 a week for me and put it into my RRSP? That's fine. You've got a pre-authorization for that. But if it's got anything to do with your business, like, they have to put a deposit down to cover the till, or they have to pay back their uniforms, do it separately. Just, get them to pay for it and buy it. Don't do it on their check, because, it never works out good for the employer. Or if anybody ever disputes that stuff, it almost never works out good. You can not deduct cash shortages from people's paychecks unless you can prove that they are the only person with assigned authorization who has access to that cash box or money. So if anybody else could walk by that till, could steal from that till, used that till, at the end of the shift, they signed out, you signed in, you can't do it. It's against the law. So, there are some places where people say, like in a casino, they say, here, this is your box. Count the money in it, use it. At the end of the day, come in and put the money back in again, sign for it. Nobody else can touch it. Then maybe that's allowed. And they tend to do that, say, for example, in casinos, because there's so many ways for people to steal money, but not if it's two people touching the same box. Agencies cannot charge people fees. You cannot charge a fee to get them a job. You cannot charge them a fee to do their resume. You cannot charge them a fee to teach them how to look for a job. Can't charge them a fee on how to improve their interview style. If you're in the agency business in Ontario, do not charge people fees for any of that stuff. If you want to set up a separate business someplace, go right ahead. But keep in mind that the reason why this was done is because of stupid things, and stupid people did things like, for example, you go to a talent agency and they'd say, oh, we need new headshots. You can't, I can't open your file until you get your picture taken. Why don't you go across the road and see Steve over there, and he'll do headshots for you. We really like his headshots. But meanwhile, they own that photography studio across the road, and Steve works for them. They charge $500 for the headshots. Then they come back and they register with the agency, and they just made their $500. This is totally illegal now. Don't do that stuff. Don't get involved in charging people fees. If you're in the staffing and recruitment business and you think that you need to charge a candidate a fee, you suck at it. Go find another job. It's really not how you make money in this industry. There are countries where people say, hey, I'll give you a job as a gravedigger if you give me your first 2 weeks pay, and we'll give you a shovel and you can help dig graves here too, but you got to pay the supervisor your first 2 weeks pay. That's something you might find in some South American country. It's lawless. It's not the kind of thing that's allowed here ever. And the best way to stay away from that is being misunderstood. Don't even do anything that could be misinterpreted. So we've got rules with respect to hours of work and weekly limits, and this gets confusing as heck. So let's talk a little bit about this and we'll move on. You're not allowed to put into a person's employment agreement. No, you're not allowed to ask a person to work for more than 8 hours a day unless it's pre-written into their standard employment agreement. So you can have employment agreements that say, hey, you work 4 12-hour shifts a week and then have 3 days off. If that's the but you can't call a person up and say, hey, from now on in, you're going to work 9 hours a day or whatever. If the employment agreement that they entered into in the first place doesn't have something different than 8 hours, you can't regularly doesn't mean you can't ask people to come in for an emergency. You can ask somebody to come in for a special shift. You can do, but regular employment agreements cannot have more than 8 hours a day. unless it was number one, pre-authorized an employment agreement, number two, covered under a union agreement, or number three, your company has gone out and sought a permit from the government to have this special standard, and then it becomes a standard part of your employment, like nurses in a hospital working 12-hour shifts. Now, three things. The hospital probably has a permit. Number two, there's probably a union, so it's in the union agreement. Number three, it's in their employment agreements. So all those things are covered. So you just, as a temporary help company, can't say, yeah, you got to work 9 hours every day from now on in for the rest of your life, and we're at the rest of that assignment. You're not allowed to do it unless they sign the agreement. So keep that in mind. You also, in Alberta, it's 12. So Alberta already knows there's a huge part of the industry working in oil rigs and different places that, offsite, that they're pretty standard for 12-hour days. So Alberta's got the 12-hour day. Most provinces set out a maximum work week of 40 hours a week. And you can ask people to work, by the way, which doesn't mean overtime. Most provinces have overtime set at 44 hours per week. You just can't ask people and require them to work more than 48 hours a week. And some provinces have a total upset limit of 60 hours where they say, hey, you got to pay time and a half over 44. You're not allowed to regularly ask people to work more than 48. And if you think you're going to ask them even during an emergency to work more than 60 and they say no, then you can't penalize them for that. They said no. They can't do it. Like, it's not even allowed. And so they just can't work more than 60. So there's different provinces have different rules. The way that they're written are sometimes a little confusing. So for example, Ontario overtime begins once a temporary employee has worked over 8 hours a day. The answer to that, and 40 hours per week, the answer to that's false. Ontario has an 8-hour day that you're not allowed to regularly employ people for, but their overtime doesn't kick in until they hit 44. So once you start asking them to work more than 5 days a week, 8 hours a day, which is 40, once they get up to 44, you got to start to pay them time and a half, which is a total different piece of the legislation than what you're allowed to ask them to do. Now, this one gets confusing. 11-hour, again, for those people in Alberta and British Columbia who are on the line, I'm sorry. This just the vast majority of people who sign up for this course are Ontario. I'm going to throw occasional examples in there for your provinces. But back to the point I made earlier, the whole point is I just want to let you know that these laws exist. Heck, they might change in Ontario. So memorizing it doesn't really matter. Just know these laws exist and know where to go look them up for your particular circumstances. So days of rest. So the title's wrong on the slide. I don't know why I never noticed that. So a person needs to get a day of rest or a day off once a week, 1 day in Ontario, 1 out of every 7, 2 out of every 14. So it could be Saturday, Sunday off in the middle of the 2-week period, which is the last day of one period and the first day of the next. It could be 1 day off on the weekend. So having 2 days off is a custom. It's not a law. Having 1 day off is the law. I'm guaranteed the 1 day off for your day of rest. But for rest periods, here's an interesting thing. Okay. A person needs to have 8 hours off in Ontario. It's different in Alberta. It needs to have 8 hours off in between shifts. So you came into work until 11 o'clock last night. You can't start before 7 o'clock in the morning. You got to have 8 hours off between shifts. But the calendar day started at midnight. And it ends at 11:59 p.m. the next night. So a person has to have 11, not consecutive. A person has to have 11 hours off in a day. I gotta change the screen. Every time I teach this course, I gotta change the screen. The person has to have 11 hours off in a day. So they could have had from 11 p.m. to 7 a.m. off. There were 8 hours off. And then after they finished their 8 or 12-hour, day shift, then they had 3 more or 4 more hours off, and they got their 11 hours off in the calendar day. So you got to have 11 hours off in a calendar day, but you have to have a minimum of 8 hours off in between shifts. So you can't have somebody say working afternoon shifts, and say, okay, now next week you start day shifts. So as soon as you finish your afternoon shift on Friday at 3 p.m., your new week starts and you got to work the afternoon shift starting at 3 p.m. Like you can't do that. You have to have a minimum of 8 hours off before the next shift can start. So you got to have 24 hours off, 1 day off in a week. That's that 1 day off on Saturday. So this is your day of rest. In Alberta, because of, I personally think this is because there's so much remote work in Alberta. Like when the oil rig started flying people out to sites and so on and so forth, they had to say, hey, look, we're going to fly them out there for 2 weeks. They're going to come home for X number of days. We're going to fly them up for 3 weeks. They're going to come in for X number of days. We're going to run this, refinery for X number of hours and we're going to shut it down. Whatever the, thing were. So Alberta, develop their labor standards more consistent with the reality of a high percentage of Albertans working in. So Alberta doesn't say it's 1 per week. It's 2 for every 2 weeks, 3 for every 3 weeks, 4 for every 4 weeks. So you could literally go to work for 4 weeks, right? Work 28 days in a row. You're only required, no employer in Alberta would do this. Lots of employees want it, but you're only required to give them 4 days off. Then you can go back to work for 4 more weeks. So you have to have 4 days off, consecutive days off for every 4 weeks of work. 3 days off for every 3 days of work. 2 days off for every 2 weeks of work. And of course, I know people personally that are, one of my buddies is he's a mechanic. And so, he goes in and sometimes he stays for 6, 7, 8 weeks in a row because he chooses to, right? And when he comes out, they give him like 3 weeks off, 2 weeks off. But he knows that when he goes in there, he can work tons of overtime, tons of money. And so, they've got it written into their agreement and he agrees to do it. They don't force him to do it. If at the end of 4 weeks, he said, look, I'm going home, then he gets to go home and get 4 days off. Now they can make him come back on the 5th day. He happens to choose to work for longer, put in more hours and then take longer periods off. And he takes lots of vacations and big trips and stuff like that. That's his life. So each province has their own rules with respect to that. And my computer is. All right, let's take a look here. We've got 10 more minutes before our next break. So overtime rules in Ontario or any other province are based upon the number of hours that are worked in a particular week. Sometimes you can have overtime hours in what we call bundling, which can be over a 2-week period. So for example, my home care company calculates overtime hours over 88 hours in a 2-week period, not 44 in a 1-week period. It's written into our agreement. We have a permit for it. And that's because people work 12-hour days. And so if you worked Monday to Thursday for 12-hour days, you'd work 48 hours in that week. We don't want to pay 4 hours of overtime if you now have 3 or 4 days off and then go back and work for 4 days straight for 12 hours. The agreement is 88 hours over 2 weeks, and then they get long periods off and long periods on. And that's just the way hospitals work, 12-hour shifts. And so, so you can have bundled hours together, modified hours under permits and under employment agreements, but typically in Ontario, it's 44 hours. BC is very different. It's more complicated. So for example, employee who has a regular rate of $16 an hour will have an overtime rate of $24 an hour. If they work in excess of 12 hours a day, then in BC, they automatically go to double time. So Alberta doesn't care if you worked, or British Columbia doesn't care if you worked 44 hours or 40 hours. They say, yeah, okay. So, but if you make somebody work more than 12 hours a day, or they agree to work more than 12 hours a day, then you go to double time right away. We're going to wait until they worked, 4 12-hour, 13-hour days to get them over their 44 hours. That 13th hour is going to be double time right off the get-go. So different provinces have different examples. So here's the BC example and how that works. So in British Columbia, we end up having this person who works 8 hours on Monday, 10 hours on Tuesday, 6 hours on Wednesday, 13 hours on Thursday for a total of 37 hours. By anybody's standard, 37 hours is not over 40 and it's not over 44. So it doesn't matter if British Columbia is going to pay overtime at 44 hours a week or 40 hours a week. The reality is that British Columbia's overtime rules are different. They said if you work over 8 hours a day, you get time and a half. So the person worked 10 hours this day. So 8 hours were at regular time and 2 hours were at time and a half. And then the other days, so then they're still only worked 37 and a half hours a week, but 2 hours on Tuesday were at time and a half. And then we get to Thursday where they've more than 12. So the first 8 hours are regular. The second 8 hours are at time and a half, 4 hours are at time and a half. But that 13th hour over 12 is at double time, is double time. So in Ontario, this person would not have received any overtime pay at all. In Ontario, it's 44 hours. British Columbia, they break it down per day and per week. So now these hours, by the way, are now excluded from the overtime hours in Alberta. So, if they got up to 44 regular hours and they weren't any of these hours already paid at time and a half, then their time and a half would kick in again. So they've got very complicated rules, and the British Columbia Employment Standards website offers a tool that you can go into, and you can enter those hours into the tool and figure out how it's all supposed to be done. And most payroll systems, if you're using Ceridian or Paychex or whoever, typically don't calculate these things very well. So you got to manually enter those numbers into the payroll system. And how are we doing? We've got 5 more minutes. So some provinces have minimum hours. Alberta has a 3-hour minimum. You can't ask people to come in to work for a 2-hour shift. Ontario, minimum of 3 hours. And Ontario introduced this thing that said, if you cancel and then they repealed it. Ontario introduced this law that said you can't cancel a person's shift with less than on the same day. I think it was on the same day. So this, again, remember I told you Kathleen Wynne before the last election when she lost, 5 years ago, or whatever it was, introduced a whole bunch of changes. One of the changes she introduced was that if your employer cancels your shift on the same day, they have to pay you 3 hours to stay home. And of course, the government came in and they repealed that law on Bill 148. They repealed that law. So different provinces have different minimums and they have different notice periods. So you got to check your provincial legislation to know exactly. Equal pay violations. I'm going to go through this quickly. I think there's a lot of slides on this. And it's not that it's not important. It's just that this particular example is Ontario. And I'm just going to use it real quickly. And it basically boils down to this. If two people, male and female, are fundamentally doing the same job, then the manner in which they are paid needs to be the same. So if they're different, if you've got a seniority thing, a man doing the job for 1 year, the woman doing the job for 3 years, and you've got a pay increase that's scheduled at the end of 2 years, then it's justifiable that the woman would make more money. Now, these equal pay for equal work is intended to protect mostly women who traditionally were underpaid for doing the same amount of work. So the example would be reversed. If a woman works for 1 year and a man works for 3 years doing fundamentally the same job, and you've got a documented pay scale that at the end of 2 years you get more pay, it makes sense that the man who's got 3 years experience and the woman with 1 year experience can be paid differently. But when the woman gets to 2 years, she's got to come up to the 3-year pay schedule. So they have to be basically, and again, this doesn't protect two people of the same sex, two women doing fundamentally the same job. One gets paid more than the other. This legislation doesn't apply. Two men doing the same job, one gets paid more than the other. This legislation doesn't apply. It's got to be a man and a woman fundamentally doing exactly the same job with all those rules. They got to be paid under the same standards. So they go through this very ridiculous complicated process. Is there a difference in pay? Yeah. Okay. Let's move on. Is there a difference in sex between in sex between the people you're comparing? Okay, move on. Yes, there is. Is there employment? Are the employees required to perform the same work, have the same skills, do it in the same place? If the answer is no, they do different work, then throw the legislation out and deal with it. If they do the same work or are at the same place, have the same skills, then move on. If the difference in pay is for the same jobs due to seniority, merit, the example I gave you before, if their pay is different because of merit or seniority, throw the legislation out. Or if you don't have a merit system, continue on. If this sort of elimination process where they say, they're saying, is this really the same? And is it really people of different genders? So most of the stuff was repealed. Ontario equal pay legislation, a lot of the changes to it were repealed. And so don't get confused with pay equity, which is equal pay. So pay equity, my computer's frozen again. So pay equity is this old legislation that really doesn't exist provincially anymore. There are some pay equity provisions in the federal government, but pay equity was really about the value of the work. So back in the Bob Ray days, before most of you people were in university or high school, back in the Bob Ray days, they introduced this notion that you would measure the value of a job. And it had to do with the hours of work, the skill that was required, the education that was required, the difficulty to perform it, the work conditions, and blah, blah, blah. And then you came up and said, oh, this is a 100-point job. All 100-point jobs, is it predominantly male? Yes. Is it predominantly female? Yes. So now you would take a 100-point predominantly male job and compare it to a 100-point predominantly female job. You'd have to make sure that the women working in the 100-point predominantly female job were paid the same manner, calculated the same way as the predominantly male job. So first off, you had to decide, what does predominantly male mean? Then what does predominantly female mean? Then you had to have this measurement system, la, 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 la. And boy, it was like nearly impossible to do. Nobody wanted to do it. It, in theory, was a way to accomplish pay equity, but employment equity was just way. So the next government came on, they repealed it. So don't get confused between pay equity, which means a man and a woman doing fundamentally the same job in the same place with the same requirements and same standards must get paid the same amount, compared to employment equity, what has to deal with how do you make work equal. I don't know. So don't get confused between those. I talked to you a little bit about hours averaging agreements. So that's when you take 44 hours, 88 over 2 weeks, 166 over 4 weeks. Those are called hours averaging agreements. You can have hours averaging agreements, and I've told you all this already, 3 ways. You could have it written into your contract. You could have it in your union agreement, or it could be that the company has sought out a special exemption from the provincial government because of the nature type of work, as hospitals have done in Ontario for hours averaging. Last thing before we take a break, and then we're going to take a 15 rules of agreements. All of these, so Ontario and most provinces say, hey, look, here's the minimum standard. Some things they say, we don't care. You cannot write an agreement to get you out of this. No matter what, the employment standards will set the minimum. So if you're going to write an agreement, it better start at the minimum and then maybe get better from there for the employee. In some provinces like Ontario and Quebec, they say this part of the legislation you cannot go under. This part of the legislation You can if you have a written agreement in advance, so long as the entirety of the amendments are better than that, than the Employment Standards Act. So you can't just go and say, oh yeah, we don't adhere to overtime. You don't get any overtime. You can go in and say, oh yeah, you don't get overtime at 44 hours, you get it at 88 because we're giving you 12-hour shifts and then you get 4 days off and 3 days on and 4 days on and 3 days off. And so the hours, and so you get the benefit of long times off and longer shifts. You don't have to travel. And so if the entirety of the amendments is better than the Employment Standards Act would generally give a person, you can have written agreements, but you cannot just have a written agreement that says, we wrote a contract that writes us out of the law. It gets us out of the law. Can no do. So the agreements must be for a certain amount of time. They must indicate work schedules and be pretty specific. They must have start dates and end dates. That this is going to be renewed every 4 years or every 2 years or whatever. It will say, this agreement can be automatically repeated by the employer every year for the next 3 years, but then we have to get a new signed agreement. They have to have begin dates and end dates, and they have to have signatures by the employees. So is it lunch yet? Yeah, we're going to take a little bit of a break. And on that note, lunch breaks are unpaid. Lunch breaks aren't the same as coffee breaks. Coffee breaks are not covered by any legislation in the country whatsoever. Lots of companies have policies for coffee breaks. Some companies only take the coffee break when the truck rolls in the back and honks the horn. But coffee breaks are not guaranteed by law. But eating breaks are. And so we're going to take an eating and bathroom break right now. It is exactly, according to my phone, 2:35, 45. So let's try to be back here. Let's try to do this in 10 minutes. Let's try to be back here at 2:45. During that 10-minute period, I'm going to turn my camera off, and I'm going to turn my audio off, go fill up my coffee cup. You guys do the same thing. Try to stay on board. And whether you're here or not, I will start up in 10 minutes from now. So we'll see you guys in 10 minutes. Okay, we are recording again, and welcome back, everyone. Sorry about the short break. There was a question that came up earlier that I wasn't monitoring the questions. By the way, I think I answered this question, and so I'm encouraging you to unmute your computer and just jump in and interrupt me when the time comes. But there was a question up in the chat section about Ottawa from Jennifer. Thank you, Jennifer. From an Ottawa-based office employing people who are placed in the province of Quebec across the border. And when, when there's a public holiday that exists that's different. So, for example, Saint Jean Baptiste Day is covered in the province of Quebec, which is I believe, the 1st of June, and May 24th or thereabouts is the week before is usually Victoria Day. It's understandable that Quebec would prefer to celebrate Saint Jean Baptiste than the Queen of England. So they have a different public holiday on that date. And the answer to that is you adhere to the provincial legislation in Ontario. However, there are provisions in the law that allow you to give a person, to ask them to work on the day, if it's written into their agreement, to ask them to work on the public holiday, so long as you give them a day off in lieu of that day off. And of course, if they worked on that lieu day, they would get paid time and a half for working on the public holiday. They would get paid their regular day's pay for staying home on that day off in lieu if they didn't work on that day. And so long as that day off in lieu occurs before the next regular occurring public holiday, that's in the legislation. So the legislation says, hey, if you would like to take off Saint Jean Baptiste Day instead of Victoria Day, and if the government's open on Victoria Day, which or the customer is open on Victoria Day, then we can ask you to work on Victoria Day, but you take off Saint Jean Baptiste Day, and you still get a regular day's pay for staying home, and you would get time and a half if you worked on that day. So the answer to the question is you always apply to the provincial law that applies to the company in the company's place of business, not the place of business or of the customer, not the residential address of the employee, but the company's place of business and the provincial rules that apply to that province. Okay. So hopefully, Jennifer, that answered your question. And welcome back, everyone. We're, I think, a little bit behind schedule. I'm probably going into a little too much detail on some of these screens, and so I'll try to talk fast. And my promise to you is we will not go over schedule. How many hours can a temporary employee work before they're required to take a break? The answer is 5. So if a person has an 8-hour workday, you can ask them to work for 5 hours. So 9, 10, 11, 12, 1 p.m. By the time 1 rolls around, they have to be allowed to have a 30-minute lunch break or eating break before they can go back to get to work again. Now, incidentally, if you happen to, for some weird reason, give them an eating break, say, for example, at 10, well, you got 5 more hours. 11, 12, 1, 2, 3. You'd have to give them another lunch break for half an hour at 3, because you can't ask a person to work for more than 5 consecutive hours without getting a break. Okay. So what about your coffee run? No, that's not covered under legislation. Doesn't require an employer to provide additional breaks in addition to the above eating breaks. So vacation entitlement. So different provinces have different rules. Most of them are based around 4%. Ontario happens to have this rule now that came into play about 6 years ago, that if you work for 5 years or more, you automatically go to 3 weeks vacation or 6% vacation pay. And if you work for 5 years or more. The law requires you to default to accruing the time and giving them paid vacation time off. So they would dip into their bucket of accrued vacation pay. So the example I gave earlier was person makes $1,000 a week, so they get $40 a week put into their bucket. And then when they go to take vacation, how much time is in their bucket that you give that money to them when they take their vacation? They can take 1 week off and get the equivalent of 1 week pay, 2 weeks off, 2 weeks pay, or whatever the equivalent of their break is. They can ask for it all at once, and they might have only accrued the equivalent of 1 week's pay, and you've allowed them to take time off more than that, but you only have to give them what's accrued in their bucket. Or you can sign an agreement with them at the very beginning that says, hey, I'm going to give you your vacation pay every week on your check. And when you take time off, you get nothing. So but it always defaults to the accrual method. And then you can have a written agreement to have it paid out on every single paycheck. So a person works part-time, earns gross wages of $16,000. She's entitled to 4% vacation pay. So she's got $640 coming to her. What if the question at the bottom is, what if Susan's contract provides a better vacation benefit than the minimum required? And the answer is, well, then she gets that. Susan may be entitled to more than her gross earnings for vacation pay. Once you have an agreement that is better than the Employment Standards Act, the agreement takes place. Remember, Employment Standards Act is a statute. Her employment agreement is contract law. If the contract is better than the statute, the contract prevails. The contract cannot be less than the statute, which doesn't mean, I'm going to repeat this again, that any one particular provision can't be less than the statute, so long as it's understood that the modifications on whole, as they're bundled together, are better than the statute on whole. So the nurses have agreed that they're going to work 4 on, 3 off, 4 on, 4 off, 3 on, 4 off, and then it's 12 hours, and they don't get overtime, for in excess of 48 hours in a 2-week period. That's fine, so long as that it is perceived to be of greater benefit to the person as a whole than just saying, hey, you don't get vacation pay until after 48 hours. Public or stat holidays. So, it's the legal term is public holidays. Some people call them statutory holidays or stat holidays. Temporary employees who qualify are entitled to take these days off for work and be paid. So a public holiday usually says that they get the day off with pay, and they can agree in writing to work on a holiday to be paid on a different day, so long as it doesn't happen after the next scheduled holiday, and so long as it's done in writing in advance, and so long as all the rules exist to the day that you have put in lieu. So we already talked about that. So in Ontario, interesting calculation, which is different, say, for example, in Manitoba, and very different from Manitoba and very different from other provinces. So in Ontario, they have got this 20 divide by 20 rule. So let's think about this for a second, just so we understand the principle of the rule. The average person in regular employment would work, say, 5 days a week, 4 weeks out of the month. And so they work 20 days in a month. Yeah, there's 31-day months, and the month might not start on the Monday and blah, blah, blah. But, if you just kind of average it out, person works 4 weeks in the month, and they work 5 days a week. And so there's 20 days, regular work days in the month. So what we do is we take the total gross earnings in the 30 calendar days immediately preceding the holiday and divide that by 20. So if a person earns $100 a day and they worked 20 days, they earn $2,000. Then the holiday comes up, they get the day off with pay. We take the $1,000, we divide it by 20. Comes out to be $100, and they get their $100. It doesn't matter if they worked 1 day in the month or if they worked 25 days in the month. If a person worked 25 days in the month, they worked extra days and they worked on Saturdays, then when you calculate it out, the day for the holiday is going to work out to be more than an average day's pay. It's going to be $2,500 divided by 20, which is going to be $10 or whatever it is. And so they're going to actually, on their day off, going to receive more money than what they working on any given day. And that's to take into consideration that they worked a lot and earned a lot of money. And so an average day's pay is calculated a little bit differently. So for salaried workers, it's pretty straightforward. You work on a salary and you get paid so much per week, and the holiday comes around, you just get your regular old paycheck the next week because it includes your salary for the week. The fact that you took the day off because it was a public holiday is fine. But for hourly paid employees, you take the total gross earnings for the month. So there are some things like for salaried employees on commission, theoretically, it's all supposed to be calculated in there, that their salary that they normally get and their commission normally get takes that all into consideration. Just got to make sure that the contracts are written in such a way that it explains how and why that's being calculated. So long as it's not coming out to be less, perfectly fine. So here's the complicated example. I'm just got to move this thing out of the way a tiny little bit. So Jordan ends a 6-month assignment on Friday, February the 16th, next week. He had been earning $800 a week while on that particular assignment. And then he's offered another assignment that begins on April the 9th, but he's not offered any assignments in between. So Family Day falls on February the 19th, which is 3 days after. Oh boy. Okay. So forget the year. One says the 2018, and the other says 2015. Oops, I'll fix that. So forget the year. He works up until February the 16th. The holiday's falling on the 19th, but he doesn't start again until April the 9th on his next assignment. Now, we haven't terminated Jordan's employment. He hasn't become unemployed, whatever. He's going to work up until the 16th, then he's going to work on the next regularly scheduled workday, which is April the 9th. So in theory, we have to calculate how much Jordan earned in the 30 calendar days immediately preceding February the 19th. Now, he didn't work on the 17th and 18th, which might have not normally had any, but he earned $800 a week. So he earned $3,200 during the 4 weeks immediately preceding. We divide that 3,200 by 20, it's $800. So now he goes back to work on April the 9th. Now we owe him a public holiday because he worked his regularly scheduled day immediately preceding the holiday, which was February the 16th. And he worked his scheduled work day on April the 9th, which was following the holiday. And so he qualified to get paid, not $800, 1/5 of $800. He earned $800 a week. So he's going to earn 1/5 of $800 for that work day. So this presents an interesting dilemma. Jordan probably didn't even know that he was going to get paid that extra day's pay when he came back on April the 9th, because in all of our mind, Jordan was laid off during that period and was not entitled to accrue benefits, or he was unemployed and he became re-employed again on April the 9th. But in the absence of a document or an agreement that says, hey, your employment is terminated and you're eligible to be re-employed, and your new employment is going to start on April the 9th. In fact, he was continuously employed but not active on February the 19th and qualified for a public holiday. Now, of course, staffing service companies are just absolutely terrible at calculating this kind of stuff because people come and people go, and employees don't know that they're entitled to this. And the ministries are not running around auditing people to try to figure out these anomalies. But this is a weird example of how the legislation should work. So that $800 divided by 5 is $160. And of course, that $160 is needs to have vacation pay added to it. So that $6.40 of 4% vacation pay either gets added to his accrual account to be taken later, or it gets added as a separate item on his paycheck as vacation pay. So he earned $160 for the public holiday, staying home, not working. And then he also earned $6.40 in vacation pay on that. And public holidays in Ontario. So earnings $800 a week, $3,200. $3,200 divided by 20 is $160 for the public holiday pay. There's the explanation of the $6.40 for 4% vacation pay. If he gets paid vacation pay on each check of 4%, then you either legally you should calculate the gross earnings, not including the vacation pay, and then add the vacation pay to it on top of that. Otherwise, you're calculating vacation pay on vacation pay. Do we care? Yeah, we care, because calculating vacation pay on vacation pay that people earned is double paying. Okay, so termination of an assignment. Termination of an assignment differs from termination of employment. It occurs when an assignment's assignment is terminated, yet they remain to be an employee of the temporary help agency. Now, in Ontario, and in statute, and in other provinces in common law, it is specifically written into the law in Ontario that your employment continues when you're off assignment. In other provinces, in common law, in most cases, a judge would say, yeah, the circumstances of this are that you continue to be employed when you're in between assignments. Hey, let's take a look at what this chat says. Is this rule different in Quebec? Do you have to accrue time for them in Quebec? No. Yes, it's the same in Quebec. Vacation pay. You accrue the time for vacation. By the way, here's something really important for Quebec. Quebec is a real stickler for showing your vacation pay calculation separate on the pay stub, like a real stickler. In Ontario, they might say, yeah, I see how you calculated this. Don't ever do this again. We're going to give you an order to comply. And from this point forward, you must show your vacation pay itemized separately on the stub. In Quebec, they'd say, too bad, so sad. You didn't show it calculated. So even though you paid somebody $1,000 and $40 for vacation pay, if you didn't separate it on the stub, then you owe them their vacation pay again. Give them 4% of 1,040. Quebec is like, I've seen it happen where they go in there and say, hey, Mr. Employer, because you didn't show it separately on the stub, we can't say that that was vacation pay. So therefore it's not vacation pay. And you could argue as much as you want. They will say, sorry, pay your vacation pay again, double pay it. And it's going to be more this time because now you got to pay vacation pay on vacation pay. So the answer is yes, it's exactly the same law in Quebec. You have to show it separately on the stub. You have to accrue it. If you don't accrue it, you have to have an agreement that says you're going to pay it out on each check, and then you got to pay it out on each check and show it on each stub. And I apologize if you hear my dog barking, but that means that somebody's visiting my house downstairs. Okay, so we're terminating people in Ontario. We're terminating an assignment. A termination of an assignment in Ontario does not mean the termination of employment. The statute, the Employment Standards Act, specifically calls out temporary help companies in Ontario and says, hey, man, if you don't terminate them, they continue. They're still your employees. They're just on presumed layoff and they're accruing time and they're still employed by you. So in Ontario, you have to give a person 1 week's notice if they've worked for 1 week, 2 weeks notice if they work for 2, 3 weeks notice if they work for 3. So theoretically, if a person worked for 3 months and then went off for 3 months and then worked for 3 months and then went off for 3 months and then worked for 3 months, you might look and say, oh, over the course of the year, they worked 6 months, they've been employed for 6 months. Or you might say, well, every time it finished, it stopped and it started again. So they've only worked for 3 months. They haven't worked for a year yet. The Ontario government says, no. And again, statute. This is written right into the Employment Standards Act. This is, and in other provinces, it's in common law. Unless you specifically terminate the employment of that employee at the end of their assignment, their accrual period will continue. Their employment time will continue to build and accrue in between. They're just laid off. So even though they worked for 3 months, took 6 months off and worked for 3 months, that 6 months is considered employment time. Now, when they start to work again for you, they're now in their second year. So theoretically, if you were to end an assignment early, you would have to give them 1 week's pay in lieu of notice because they've worked for you for a year. In your mind, they've only worked 3 months. Maybe even in the employee's mind, they've only worked for 3 months. Or maybe in the employee's mind, in your mind, they stopped working, they were no longer employed, and they started a new employment contract. But the statute and the common law says they've continued to be inactively employed and building time. So now they're in their second year. They're entitled to, because they've now completed 1 year of work, they're now entitled to 1 week's pay in lieu of notice. And in fact, in Ontario, it's kind of weird anyways. It's like you work for 3 months to 2 years, you're entitled to 1 week notice. And as soon as you finish 2 years, you're entitled to 2. As soon as you finish 3 years, you're entitled to 3. But the timer actually starts at 3 months. So, and then it goes all the way to the end of the second year, they're entitled to 1 week's pay in lieu of notice. It's weird, but it's true. So, so what does this mean? This means that unless you know that a person is going to start an assignment really soon, again for you, then you should terminate their employment. It can be a nice termination. It can be, hey, Jane, Johnny, you did a great job. We love your work. You're totally entitled to work for us again in the future. Now that 6-month assignment is over, we're notifying that your employment with us is complete. We've paid you your vacation pay, or here's the money we owe you from vacation pay that's in your accrual account. Please don't hesitate to apply for us for future jobs. And then when the next assignment comes along 3 weeks, 4 weeks later, again, you employ them again. And you issue them a record of employment so that they're now eligible for unemployment insurance and so on. And you say shortage of work, terminated. But in the temporary world, specifically in Ontario, in the absence of a termination, their employment, we refer to it as continuity of employment. And it's in the statute and in other provinces in common law. So in Ontario, they specify a difference between termination and severance. Termination is when you fire a person or end their employment with you, and severance is the amount of money that you pay a person who's worked for you for 5 years or longer, and if your company is of a certain size. So there's the termination of employment and termination entitlements, and then there's severance pay. Now, in the rest of the world, the term termination and severance are often used interchangeably and indiscernibly. And so we don't talk about the difference between severance and termination. But in the legislation, in the statute in Ontario, they specifically use different terminology to define what a person is entitled to. So a person is entitled to notice of termination or pay in lieu of notice for termination in Ontario if their work comes to an end for any reason other than cause. And in Ontario, they've added this notion of severance, which is a separate amount of money that must be paid, cannot be exchanged for notice. It's a separate amount of money that must be paid to people who have worked for 5 years or longer, and if the company is of a particular size, if they're big. And I'll give you the definition of that, I think, on the next screen. So in the case of severance, other than the severance that results from a layoff, so you can lay somebody off, which puts them into a temporary status. It's not termination, it's a layoff. In the case of severance results from a layoff, so we gotta then figure out what their average week's pay is by taking the amount that they earned in the last 12 weeks and divide that by 12. So it's not the exact same calculation to divide by 20. So calculating severance pay and termination pay is a different calculation than calculating the calculation for the purposes of paying someone for public holiday. Confused yet? A week is counted when a person is laid off, is not counted when an employee is not available to come to work, if they're not able to come to work, if they refuse to come to work, or if they're subject to a disciplinary suspension, and if they're not. So if in those particular cases, when a person is laid off and you're trying to figure out, oh, how long is this layoff period where we're accruing their employment time, but we're not required to pay them severance pay or termination pay, you can continue to extend that period out for longer than 35 weeks. If, for example, you phone them up and say, hey, can you come back to work on Monday? And they say, no, sorry, I can't. My kids are home from school that day. Okay, that week doesn't count. So now you've extended your 35 weeks to 36 weeks because you can't count that week when they were not able or not available or refused to work as one of the weeks in their layoff. Now, of course, if a person refuses to come back to work like 2 or 3 times and they're not available 2 or 3 times, now you can terminate them for cause and just say, hey, this is constructive dismissal. Like you're not available to come to work. You don't work for us anymore. Now you've triggered severance or termination. You have to determine whether or not that cause is enough to exempt you from paying them, because you don't have to pay a person termination or severance pay if you sever them for cause. What is cause? Willful neglect, willful disobedience. So if a person knowingly neglects their duties, willful negligence, willfully, knowingly acts in a negligent manner willfully or negligently disobeys you. So if you tell them to come back to work and they say no, I suppose that would be willful disobedience, and you could call that cause and not have to pay severance. So I don't want to go into like a ton of examples of how you don't pay people. What I want to say is this. In the temporary help world, if a person doesn't continue to work for you because they're between assignments, unless you sever their employment, and you can do it in a professional way and in a friendly way, in a way that doesn't harm your relationship with them, if you don't do the paperwork to document the end of employment, their employment period will continue. There will be this continuity of employment, and they will continue to accrue time. In the absence of a person being terminated, being in a temporary layoff position for 35 weeks or more triggers a termination. So theoretically, if people just, you don't call them again for 35 weeks, you've now terminated them because their layoff period has come to an end. Now you probably owe them some termination pay, some notice of pay or termination pay. We don't want to be going back 6 months later and paying people money because they finished an assignment and we never heard from them again. You got to terminate people properly, end it, document it properly. Then you don't have to worry about them accruing time, building time off, getting, how to calculate the days and the weeks that they refuse to work and were unavailable work to extend your time period. Just terminate them properly and friendly and professionally. So here we go. So in Ontario and most provinces, you either have to give people notice of termination, which could include that end of assignment and termination. Remember, end of assignment doesn't mean termination of employment, but you can orchestrate it in such a way by communicating effectively. At the end of this assignment, you're no longer employed by us, so long as you give them notice. And you can give people, and the law requires you to give notice. The law doesn't require you to give pay. Now, you can waive notice and give them pay in lieu of notice, but the law requires you to give them notice. So your assignment's coming to an end at the end of next month. You've been on this assignment for maternity leave for a year. We got 30 days to go. You've been with us for 1 year. You're entitled to 1 week notice. I'm notifying you that at the end of this assignment, your employment with us is complete, and that assignment is complete. Thank you very much. You've been awesome. Here's your eligibility. We'll issue a record of employment. You've got your vacation, or you're going to get your vacation, whatever it might be. You do it properly. You've given them notice. In the absence of notice, you can give people pay in lieu of notice. So now let's think about the person in your office, your coworker, your employee who's working for you. You just want to fire because you just want to fire them and you don't want them around anymore. They're not being productive or something, but you don't have enough to notify them for cause. You can say, hey, Johnny, we're going to end our employment relationship with you effective today, but you're entitled to 1 week's notice. So we will pay you 1 week in lieu of that notice to sit at home and or to not be here. So if they work for less than 1 year, give them 1 week. If they work for 1 year or more, but less than 3 years, remember I said, so that beginning to the beginning of the third year or the end of the second year is 2 weeks. Once they started their third year, 3 weeks. Once they started their fourth year, 4 weeks. So you can give them a combination. You can say, I owe you 4 weeks notice. It's probably going to take a week to clean up your desk and to do stuff and finish that report and do these things and show somebody where to find your keys. But so I'd like you to come to work next week, and then the next 3 weeks we'll give you pay in lieu of notice. So you can give people notice, which is the de facto fault in the legislation. You can give people pay in lieu of notice, or you can give somebody a combination of pay and notice, so long as it adds up the right amount of time. Now you can see that British Columbia in this example is slightly different. It's after 3 months. Now, you gotta correct me if I'm wrong, but I'm pretty sure in Ontario, you qualify from 3 months, but this table doesn't say from 3 months. but it's very possible that because you're calculating it over a 12-week period, that you're actually calculating less. So say the person worked for you for a week. You take that 1 week and divide it by 12, which is really 1/12 of a week. That's the amount of notice that they've entitled to earn. If they've worked for you for longer than 3 months, it'll actually work out to be a week. So you can double check that. But every province has got very often almost exactly the same outcome, but for whatever reason, they've chosen to write it differently. In Alberta, you got to work for 3 months, but less than 2 years. So Alberta is very similar to Ontario. From 30 days to the end of the second year is 1 week. Once you started your second year, it's 2 weeks, but it's from 2 weeks from the beginning of your third year to so that's the same thing. So from the beginning of your third year to the beginning of your fourth year is 2 weeks. So they've got very different wording, slightly different outcomes. And again, it's not important for you to memorize this stuff. It's only important to know where to find it. So in Ontario, I mentioned to you this terminology. So extra compensation called severance, those are the air quotes, severance pay is added to termination pay or termination notice for qualifying employees. It's not the same as termination. They qualify for severance pay if they've worked for the employer for 5 years or more, including that time that might have been accrued that you didn't sever them, but they were laid off or whatever, whether continuous or not. So it was whether it's continuous or not. And the employer has a payroll in Ontario of $2.5 million. So if you're a temporary help company, you probably do have a payroll of $2.5 million or more. And because that's what, 50 temps or something, I don't know. And, or if you severed 50 or more employees at the same time or in a 6-month period. So if you had a big contract with a customer and you had like 100 people there and they said, oh, darn, we have to end now, and you didn't give people notice, you would have to give them notice, termination pay. And if it was more than 50 people, you would have to give them severance pay. And severance pay is calculated very similarly to termination pay 1 week per year, up to a maximum of 8 years. I talked earlier about leaves from work. I'm not going to go through all the various definitions, but pregnancy or parental leave for both mom and dad, personal emergency leave, family medical leave, family caregiver leave, critical care leave, organ donor leave, reservist leave, crime related to a child's, by the way, crime related to a child's death and disappearance is kind of like, of course, who wouldn't want to give people time off for that? But this, I think things like reservists, the reservists get more benefits than the child disappearance. It's kind of weird. It's but exactly. So pregnancy loss leave. So a premature death of a child up to 12 weeks. Family up to 27 weeks. Just said my internet is unstable. So hopefully you can still hear me. If you can't, that's not good. Anybody want to jump in, turn the mic off and say, yeah, I can hear you? Okay, you can hear me? Yes, no,
I
yeah.
can hear you.
Okay, all right, good. Yeah, sorry, I have other people in the house, and sometimes they start downloading movies or something like that. I don't know if it interrupts with us or not. So, these leaves are not with pay. These leaves are guaranteeing you fundamentally the same job back again when you choose to come back, as long as it's within these periods. So there's, and there were other leaves too that the Ontario government introduced at the end of before the last election that were repealed. But this one of the new ones in Ontario is domestic violence. If you're employed for 3 months, you can get up to 10 days or I don't know, 15 weeks. And the first 5 days are paid leave, which is different from some of the others. So, it's, in my view, it was a really knee-jerk reaction. I'm not saying that these aren't necessary entitlements to people. I just think that they were all done at different times for different reasons, and it doesn't feel consistent to me. They probably should go back and say, hey, let's take a look at all these leaves and figure out if this is the right amount of time and whether it should be paid or unpaid. Because to me, some things, maybe it's just my opinion. Some things are feel like they're more important than some other things, and some things are paid and some things are not paid. And anyway, this is a reasonably new screen, and it looks like this because it was literally cut and paste from the government's website, and just framed so it would fit here. So I'm not going to spend a ton of time on this. I keep saying that, but then I do. There are some temporary measures in most provinces. These are examples of Ontario that have to do with COVID worker income protection benefits. So workers in Ontario who are off because their business was closed, or because their children were home from school, or because you're a healthcare worker and you're terrified to death to go back to work, you don't want to take a vaccine or something like that. You're afraid of masks. Nobody has to explain why they're not coming back to work. All they have to say is COVID, not coming back to work. And the government postponed a lot of these leave time periods. So if you took off family medical leave, or, critical illness leave or something like that, then you could postpone the time and the dates that they came back. The other thing that the Ontario government did last year, which was an interesting workaround, and I'm going to tell you that I'd like to take credit for this one, although I don't think they would do that, or they probably don't even know where it came from. But there was this big, huge hoopla over, people taking time off, and the most vulnerable workers were getting, treated the worst, that they either had to come to work and take risks, or when they got time off, they had no benefits, no paid time off. And then it was like, this is the government's fault. And it's like, paid time off is usually a company policy. It's not like and then you've got these little businesses that are trying to operate a restaurant and they're closed down most of the time. And now you're going to force them to pay time off, and you're going to definitely put them into bankruptcy. So there was this whole thing where people who were whining and complaining about paid time off really weren't thinking it through from all perspectives. And, most big companies already did have paid time off policies, and most little companies, didn't have them, and they were getting hammered the hardest by COVID. And so why would they, if you put it into the Employment Standards Act? So, I wrote a couple op-eds and did some things that basically said, the only way that the Ontario government has any mechanism whatsoever, the Ontario government doesn't pay taxes. They don't collect taxes and income tax. They don't have your SIN number. They don't put direct deposits into your bank. That's all federal government stuff. So the Ontario government had no way of even paying people, because they didn't know who you are. They don't know your SIN number and your bank account number. And, is every employee going to be required to register some sort of pay me if I call in sick thing? But the Workers' Compensation Board does have a mechanism to collect and pay money to companies. The Workers' Compensation Board in Ontario gives people rebates and refunds and collects premiums every single month. And they already have all that banking information and account numbers. So we basically, in Ontario, said, all right, if we're going to guarantee people 3 days off with pay because they are showing symptoms, and our policy says you can't come to work showing symptoms, or because you got sick, or because your kid got sick, or because your school closed down, let's not people to go to the doctors to get proof that they're sick, because doctors won't see you anyways. It's COVID. You can't get an appointment with the doctor. So let's just take people's word for it and at least once a year, because presumably if you get COVID once, you back in the Delta day, you probably shouldn't get it again. And so that was Delta and not Omicron Omicron wasn't even around when this was passed. The mechanism through the Workers' Compensation Board to collect and pay money to companies. So why don't companies put claims in for people who took off sick? So if you don't have a benefit plan, or if you don't have a policy that pre-existed this legislation, then a company could say, okay, Johnny, you need to take the next 3 days off. You're taking symptoms. Don't come back till you've tested negative and or your symptoms have gone away. We can't pay you forever, but we'll pay you for the first 3 days. And hopefully in 4 days from now, you've got a negative test and you can feel better and you come back to work. And so then the company pays the person their 3 days pay as usual and submits the bill through an online portal that was really easily created with the Ontario Workers' Compensation Board. And they submit it. And then, in a reasonable period of time, the Ontario government, Workers' Compensation Board, reimburses you for that 3 days pay. Now, it doesn't cover vacation pay, and it doesn't cover unemployment insurance premiums and Canada Pension Plan premiums and employers' health tax. So there was a little bit of cost to the company, but the cost was generally somewhere between 15 and 23% of the total actual cost. So if you wanted to implement a policy of pay, and employees were guaranteed this benefit, so most employees didn't know they were guaranteed it, and so it was up to their employers to say, hey, we're going to pay you for 3 days. But if you walked in the door and say, hey, I'm entitled to 3 days off, I don't feel good, pay me for the next 3 days. Now, it's a one-time thing per employee. It's not a one-time thing, and it doesn't apply to companies that already had a policy in place for 8 sick days a year, or 6 days a year, or 10 sick days a year paid leave. It doesn't cover companies that have got on short-term disability insurance or whatever. But paid infectious disease emergency leave was set to end on September 20th and was later extended to December 31st because Omicron continued, and now it's going to be extended in Ontario to July 31st. So if you've got working for you who have to take time off because of this, you should listen. If you're an owner and operator, I hope you know this. If you're working on a desk, then you should talk to your managers and owners about it. But you should be able to say, okay, Mary, we'll pay you for the next 3 days. We'll put the application into the Workers' Compensation Board, and hopefully you're good to come back to work in 3 days from now, that you're not really sick, or your kid's better, or you've tested negative or something. And if they got to go off for longer, the government doesn't require us to pay them for longer, but it does require that we guarantee their job back when they get better. So non-unionized employees with temporary reduced or temporary eliminated hours of work for release related to COVID is deemed to be job protected. So this infectious disease emergency leave is considered to be this like extended job protected layoff. So these people are considered to be laid off if their employer temporarily reduces their hours or eliminates their hours. It's not considered to be constructive dismissal. So in other words, to protect the companies, you can't turn around and say, I'm suing or I'm going to the Employment Standards Branch to get severance pay because they cut my hours in half. Because before this, if you cut an employee's hours in half without ever getting it into their agreement and having negotiated settlement on that, if you just said, hey, I'm cutting your hours in half, then you could go back and say, that's not acceptable to me. You hired me for 40 hours a week. You cut it to 20. This is constructive dismissal. I would like you to pay me notice or pay no notice. And they would win. If the Ontario government came along and said, look, if people are laid off now and you cut their hours in half because of COVID, then they can no longer come after you for constructive dismissal. They're just going to have to wait till this is all over with, and we'll set a new date. And so they did set a new date. They've extended it twice so far, and the next new date is July 31st. So the clock resets on July 31st. So if people are not back to work by July 35st, then that 35-week layoff period starts, or the constructive dismissal argument starts again, and so hopefully by the time July 31st rolls around, we're through this and have set it aside. There's a new law in Ontario, and I expect this to occur in other provinces, and it's sometimes some places covered under common law. And this is that if you have 25 employees or more, and people are working from home, you have to have a policy that says when they're not working. So you can disconnect from home, and if you're working remotely, and say, hey, I'm off the clock. I don't have to answer my phone. I don't have to answer my email. I don't have to respond to your text messages. Here's the company has to write a policy by the end of June and make it available to their employees and put it into effect so that people who are working from home are not perpetually actually on call and on duty, and they can't be punished for not answering their phone, answering their text message, or answering their email just because they're working from home. The other thing that the Ontario government introduced recently, which again is very often covered in employment contracts, it is definitely covered under various forms of common law, and now is written into the statute, has to do with non-compete agreements. So this already went to court and was challenged. So if a non-compete agreement already existed prior to the existence of this legislation on October 25th, 2021, then that non-compete agreement stands. But if new contracts are written with employees starting after October 25th, then you cannot, by law in Ontario, put a non-compete into the agreement. So what does a non-compete means? Well, it's generally been perceived in common law in court cases in the past. The most lots of non-compete agreements that were written into people's contracts were unlawful or unenforceable because they were overarching. So the compete agreement might have said, in days of yore, if you work for this company, you're not allowed to work for any other company in the same industry for the next year. Well, that's just redonkulous. I mean, what if I go to work for another company in a different jurisdiction? What if I go work for another company in a different role? What if I go to work for another company that doesn't serve any of the same kind of customers, but it's considered the same industry? How could you tie my hands and have the power to restrict my ability to earn a living, Charter of Rights and Freedoms, my restriction to have the freedom to choose who my employer is or isn't, and to work or not to work, and when I'm not causing you any harm? How could this non-compete is so overarching that in most of the cases where I might go to work for somebody else, I'm not causing you any harm whatsoever. And so lots of non-competes started to change their wording as various common law decisions and contractual decisions were contested in court, and judges basically deemed them to be overarching. And in some cases, contracts did not allow for a contract to be terms of a contract to be severable. And so because one clause became unenforceable, the whole contract was thrown in the garbage. And so they started to say, okay, first off, if any term of this contract is non-enforceable, the rest, they started putting clauses saying if any of this clause of this contract is unenforceable or is deemed to be unlawful, then the rest of the contract still exists. So that was one thing, severability. And so the second thing was lawyers got involved and they started to say, okay, let's try to redefine non-compete to be more specific. Is it within 5 kilometers? Is it with the same customers? Is it selling exactly the same thing? Is it, they started to try to come up with these wordings that made it more enforceable, because it actually meant something, that if you went to compete, that you would be using some sort of confidential information and you would be causing some harm to your previous employer. Hey, by the way, I'm sorry, I just noticed another chat up here. If contract is longer than 3 months and ends, okay. Is this real different way? if a contract is longer than 3 months and ends early 1 week. Okay, I'm not really sure of the question, but I'm going to answer that question to what I think it might mean. I'm jumping out of context here for a second, going back to the last severance. If you give a person a contract that lasts for a certain period of time, say 6 months, and if in your province, your must pay, give notice of termination or termination after 90 days. If your contracts end, if the temp assignment ends early in the first 30 days, you owe nothing, because in your province, you don't owe anything until after 90 days. If in your province, like Ontario, it ends in the first 90 days, then you have to use that calculation, which would make it a very small amount of money in a very small amount of time. Now, if you have, let's just say, for example, a 6-month contract and the person works for 5 months, they're clearly over the 3-month period. They're entitled to 1 week's pay and notice, and your contract ends. You really want to go back to your customer and say, hey, this goes back to my thing at the beginning. Why do you want to know this stuff? I want to know this. I consult with my customer. I want to make sure my agreement with my customer says, if I've got a 9-month contract or a 6-month contract, you'll give me 1 week's notice before you end the contract. So I can give the employee 1 week's notice. So you pay me, I pay them. Blah, it's all done. And if you're going to terminate it right now without any notice whatsoever, that the customer is going to pay me pay in lieu of notice, so that I can pay them pay in lieu of notice. And sometimes you can't get those agreements with the customer, and the customer terminates it right away, right on the spot. And you're going to terminate the employee right on the spot. Now, you got to remember, the termination of an assignment doesn't mean the termination of employment. So now you sit down with your employees and say, okay, we got 35 weeks to lay this person off. Can we get them back to work someplace in the next 35 weeks, and then give them, even if it's 1 week, and then give them 1 week's notice and terminate their employment at the end of that 1 week? Because if we can meet our objectives. So if the client has them work for longer than 3 months, but the client ends it early, but your temp assignment was for 9 months and you put it in writing, it's going to end in 9 months. Now you're terminating it early. Now you're saying, oh, I don't want to terminate their employment. I just want to terminate their assignment. And if I terminate their assignment, I now am putting them into layoff. I got 35 weeks while they're laid off to get them another assignment. Now I'm going to use the end of that assignment as my notice period, and I'm going to terminate their employment at the end of that assignment, so that employment termination and assignment termination all meet the 1 week notice. So the other thing is, you could terminate their employment or assignment, not terminate their employment. You got 35 weeks in layoff, but they get frustrated with waiting for 35 weeks. So they'll get another job. And during that time period, if they had another job, they became unavailable to you. So you phoned them up and said, hey, you want to come back to work tomorrow? And they said, no, I got another job. You went, great. That alleviates me of my notice, because you've met the termination thing, that you did not make yourself available to come back to work when called back to work. These are games. It's reality. But, do you really want to be going through how I have to count the weeks? Did I get them notice? Did I document? Did I give them another assignment? Were they available when I called them? Am I counting 35 weeks? Do I end up paying them in a 6 months, 35 weeks from now? Just try to get an agreement with your customer that says they'll give you notice at the end of the assignment. Try to give the employee notice. Try to terminate their employment at the end of each assignment, unless you're sending them back to work again. Or go into the end of each assignment. Like, for example, in my home care business, we don't terminate their employment at the end of every assignment, because I got an assignment for them. I've got 100 assignments waiting for 5 people that are going to end their assignments this week. So the 5 people whose assignments come to an end, I got 100 choices for them to start next week or tomorrow. So we don't terminate. But in the temporary help business, it's different, like in the standard normal temporary help business. So hopefully that answered that question before. Let's go back to non-compete for today. Non-compete clauses are not the same as non-solicitation clauses, and they're not the same as confidential information clauses. So most lawyers have tried to sort of get the non-compete clauses out of contracts, and they put in non-solicitation clauses saying, if you stop working for me, or if you're working for me, and for a period of time after you stop working for me, for a year or two, you're not allowed to solicit my customers. You're not allowed to solicit my candidates. You're not allowed to call my temporary workers, employees. And so if you said, by you soliciting, by trying to get the business of my customers, you're causing harm to me. In other words, while you're working for me, I gave you a duty of care to look after my customer, and then you stop working for me and you use that information to solicit my customers and cause harm to me, I've got the right to stop you from using the privileges I gave you against me in the future. I've got a right to protect myself from you causing me harm. And so we're going to write that in the form of a non-solicitation clause, not a non-competition clause. So in other words, if you want to go out and get brand new customers that I'd never heard of before and solicit them, it doesn't cause me any harm whatsoever. Fill your boots, go have at it. If you want to come after my customers and use the information, the relationship, and the privilege that I gave you to deal with my customer while you were here, and then use it against me and solicit them the day after you leave, that I'm entitled to restrict. So the Ontario government prohibited the use of non-compete clauses, but they did not prohibit the use of non-solicitation clauses. Notwithstanding that, we're also, nothing has been said, and the use of confidential information will always exist in contract laws, that an individual cannot use confidential information that they gained while being paid by you and then use that confidential information for their own unique benefit that could also cause harm to you. So knowing the names of the customers and the prices that you charge the customers and the rates that you pay your workers, this is all confidential information. And so the tools that you use, the training that you had. So these are all documents and processes that are all owned by the company. So the use of non-solicitation clauses still exist. The use of confidential information restrictions, prohibitions still exist. But the government has said, yeah, but we're not going to allow you to just wholly take non-compete clauses, throw them in there and stop people from getting another job. So there's the difference. And those laws were just introduced in October in Ontario. If contractors no longer notice, I think I answered that question. That severance, termination is notice and or pay in lieu of notice. So going back to the question before, the question was, do I have to give notice? I am not given notice. You want to get notice, you want to give notice, you want to do all the things I said to try to orchestrate notice. You're always entitled to give, in terms of termination, to give someone the money instead of the time. So the law says give them notice. The law says if you can't give them notice, give them the money, the equivalent amount of money for notice. Okay, back to this one. Here we go to the next screen. Okay, here's a new one. And licensing in Ontario for employment agencies, recruiters, and are we supposed to be done at 4:00? Yeah. Licensing in Ontario used to be a thing years ago. About 2011, we got that licensing repealed because it was silly and stupid and nobody ever did anything about it. It required you to pay $500 a year to have a license, but they didn't have any rules. They didn't have any policies. They didn't ever take any licenses away from people. They didn't ever penalize people for violating the terms of their license. So we finally said, look, stop giving people a tin badge, a false certificate to hang on their door and make the public think that it's worth something. Either make it worth something or take it away. They chose to take it away. This government has now introduced licensing, and this is because lobbyists have basically convinced governments that agencies and temporary help services will take advantage of candidates at every turn of the book. And so if we license them, then they've got a mechanism to watch over you, punish you. And so they're now in the process of trying to figure out, there's a tender out right now by the Ontario government to find a company that will help them set up a licensing database method for companies to register, upload all their documents, keep up to date, put all their information and pay their money. So sometime in the next year, we're going to get more details about how this licensing regime exists. Licensing still exists, and it always existed in, I think, the province of Alberta. Not in, maybe in Manitoba, not in British Columbia. Every province is different. In my opinion, don't be too excited about licensing to help you. I think it sends the wrong message to the public that some other industries, call centers don't need to be licensed, but the temporary staffing service that sends people that work in the call center have to be licensed. Is the problem really the temporary staffing service who's looking out for the best interest of the people working in the call center, who's paying more than minimum wage, controlling the call center, saying no, they can't work for, paying time and a half? I'm not saying bad things about call centers. I'm using that as an example, but is the problem really the temporary help company, or is the problem the company that's using the services that breaks all the rules and makes it really difficult for the temporary help company to exist? So, I don't know. Don't get excited about it. I have a difference of opinion. I was there and fought to get it repealed and successfully got it repealed in Ontario. The current ACSESS board seemed to be in favor of licensing because they thought that every ACSESS company will qualify for a license and dirty dogs won't. So maybe, I don't know. Let's see. Just really depends on how it's implemented and rolled out, and what kind of rules and how they monitor it. So I talked earlier about reprisals. Reprisals are a law in the law that says you can't punish people for asking for the law to protect them. So if a person says, hey, I'm entitled to time and a half for working on a public holiday, and they say, no, if you want to get time and a half for working on a public holiday, don't work on the public holiday. I won't pay you time and a half on the public holiday, and I'll never give you overtime ever again. That's a reprisal. That's threatening to punish a person for asking for what they're entitled to within the law. And reprisals are punishable under the law, and they are typically heavy-handed punishments. I don't know the answer to this question off the top of my head, by the way. The question is, how long do you have to keep documents around for? And the answer is, it depends. It's like adult diapers. It depends. It depends on the circumstances. Some documents, payroll documents, have to be kept for 5 years. Some documents, like application forms, have to be kept for 3 years. So my opinion is, when it comes to record keeping, here we go. Most information must be kept for 3 years from the last date of employment. Vacation and vacation calculations have to be kept for 5 years. Why? I don't know. Employee's name and address and starting employment must be kept for 5 years. Documents relating to their leaves of absence must be for 5 years. Hours of work must be kept. So I always say keep everything for 5 years. Like, don't the most information for 3 years. Just keep it for 5 years. I mean, why would you want to say, we keep all this in the same database, or we keep it in the same file? How do you purge stuff out of a file folder and go through them all and say, we're going to keep that, we're not going to keep? Just, the law says, some things in the law say 3, some say 5. Keep it all. In my opinion, keep it for 5. You never know when you're going to get audited, when somebody might file a complaint, when you have to pull up this stuff. So there's this new, it's not new, 2011, I think is the date. I can't remember. There's new provisions in the Employment Standards Act in Ontario. Most of these exist in common law. In other provinces, they define a temporary employee. They define a temporary help agency. They give people the right to get paid on public holidays. They give them the right to notice of everything I've talked about so far are covered, but they specifically say that now temporary agencies are included. And I'm going to come to this elect to work thing in a minute before we wrap up today. I'm going slower today than usual. I don't know why. I'm sorry. I'll try to talk fast. The maybe because I don't know why. But there's a specific section in the legislation now that talks about temporary help agencies. Temporary help agencies used to be exempted from a bunch of areas of employment standards, and I'll explain that to you under elect work. But there's also new things. So instead of taking away the exemptions, they also added new things. New things like you have to give a person in writing the client's legal business name and any other names that they might use. So my home care company is called In-Home Assisted Living, and our brand name is called Qualicare. So we have to legally tell people we are Qualicare. No, we are In-Home Assisted Living operating as Qualicare. So if you've got a legal name, Alberta numbered company 74329, operating as the temp guy, then you need to give both those names to them. And if your customer has those names, then both names, you have to give them both the names of their client so that they know who they're dealing with. And I think the complaint was that, people are using temporary help companies to create layers of obfuscation to avoid responsibility, to hide, under blankets of, covert operations or something like that. So you got to give legal names. You got to give in writing, the wage rate, any benefits, the hours of work, the descriptions of the work. One of the big complaints prior to this legislation was that, you'd call people up and tell them they're going to have one job, and when they got there, they'd do something else. This was common in the call center industry, where you'd say, we need you to do inbound customer service. Then they'd go and they'd be outbound selling porn or something, that they'd get there and say, I'm totally offended by this job. I'm not doing outbound collection calls, or doing these things for this dating agency. I'm not doing this stuff. I'm an inbound customer service rep. And they would say, too bad, so sad. If you don't do this, you're fired. And, we'll never let you work for us again. That's a reprisal. So they made you put it in writing, the client's name, their legal name, your name, the legal name, the hours of work, rate of pay, description of the work. That should all come out of your system in an email when you're confirming a person's assignment with them. You need to keep better records and have those records available. One of the interesting things is that your customer is liable for wages that you don't pay. So if your customer pays you and you don't pay your employee, the customer can be charged again. You can go to the employment standards branch and they can say, ABC company, I worked there on assignment, but XYZ temporary service didn't pay me. Then ABC company, even though they might have paid, the temporary staffing service by law is going to have to pay again. So they made made them jointly liable. So you've heard of joint and severable liability. So they made them jointly liable. So the fact that they paid the company doesn't alleviate them of their responsibility to ensure that the workers get paid. So those are some things that got added to this joint liability. So customers should want to know that they're dealing with a temporary staffing service that they can rely upon, that's financially stable. And if you think that your customer is dealing with a competitor of yours, cheap, under the table, and they say, yeah, no, those guys charge us like way less money. You say, under Bill 148, amendments to the Employment Standards Act, you're jointly severable, reliable. If they don't pay their workers, the Employment Standards Act should show up here and get your records and force you to pay. Like, that's the law. They specifically name temporary employment agencies and their customers and saying customers are not off the hook. So, you might be doing business with them, but what kind of liabilities do you really want to have? So, there's something in our favor, I think. They also passed Bill 18, which has to do with same thing. There are some things about liability, joint liability, and lost wages. They talked about negative background screening. We're not allowed to use employment agencies to say bad things about people, to harm their ability to get jobs with our competitors or with our customers. Under the Occupational Health and Safety Act, they also added things saying if you're going to send in co-op students who are unpaid. So there was a bunch of colleges that were operating temporary help services. And they like temporary help services and they called themselves temporary help services, but they weren't charging any money because they were sending their students out for co-ops for working in radio and television and working in hospitals and long-term care facilities and stuff like that. And so now those people have to be reported as if they had a wage so that they can be covered under workers' compensation. Okay, so boy, I think I did it. 3 minutes ago, I said we'd be done on time. I talked fast. I got us to the end. I might finish 1 minute early to say I finished early, pound my chest. Why do we want to do this stuff? We want to do this because we want to have a great relationship with our employees and so that we can retain those employees and make money and reduce the cost of high employee turnover. We want to have a great relationship with our customers so that they rely on us for good advice and adhering to the law and keeping the employment standards folks and the safety folks out of their business because we're following all the rules and acting safely. We want to get repeat business from those customers because repeat business is profitable business. And so being really, really an expert in employment standards and in your business is going to work for you as you move forward. Well, I talked about Bill 118, so I don't need to talk about that anymore. And you can get all of these posters that look like this and other posters and brochures by going online and downloading them from your employment standards branch of the ministries of but in Ontario, they changed the name to Ministry of Labor and Skill Development. So they bundled training into this process. And co-employment is a thing that used to exist. It just meant that the customer and the staffing agency had shared responsibilities. And they've written that into the law. So we don't really talk about co-employment anymore because it's written into the statute, but in common law, it is still a thing. So, you got to take a look at it and say, who's got responsibility for what in these three-part relationships that they have to do with setting pay rates or terminating people or hiring people. But every relationship in our business with a customer has got three parts of it to it. There's one employee, two employers, shared responsibility for paying wages, shared responsibility for following law, shared responsibility for a safe workplace, shared responsibility and all those things. So, your customer needs to trust you and you need to be knowledgeable. You can mitigate the risk by being upfront, by having great employment contracts and great customer contracts. You want to meet with your customers and discuss these issues. You want to also meet with your employees and make sure that they understand who's responsible for what. Please continue to perform safety reviews, employment reviews, coaching reviews, counseling with your employees. Establish you are the employer and try to protect your customer from being sued because they didn't get access to a benefit or something that took place in the customer's workplace. Pay your employees on time, pay them the right amount of money, partnerships with them, and you will, you'll end up having a profitable business. This slide, stand in your customer's shoes, really is about co-employment. It's about you asking your customer, what do they want to know? What do they want to be involved in? What do they want to control? Are you communicating with them about who's going to take responsibility for each one of these aspects? Show them your insurance, show them your access certificates, get involved with them in that respect. And we're not doing any multiple choice. We just talked about co-employment. This elect to work, oh my God, it's not a thing. It's 4:00. Elect to work used to be a thing in Ontario where it said in the law, a person has the right to elect to work when you work for a temporary service company, staffing company. The individual has the right to work or not to work when requested to do so. In other words, you can call them up and say, hey, you want to go to work on Monday? I got an assignment. You could say no. You could go back into the roster of available employees. And because of that, you lost a whole bunch of protection. The law used to exempt temporary help companies because they'd say, well, this person had the right to say no. And so why would we pay them for that? Or why would we give them that? This person had the right to not accept that assignment. So why should we have to give them public holiday? And why should we give them overtime? They had the right to say no. And we just removed that entirely in 2011. This elect to work thing is not a thing anymore. If you ever hear anybody say, no, you're not entitled to that because you have the right to elect to work, just say to them that's not a thing anymore. That was a thing that got repealed a long, long time ago. Remember that this new legislation does not allow you to charge fees for hiring an employee to your customer in Ontario after they've worked for you for 6 months. So if they've been on an assignment from the first day of their assignment to the date that the customer wants to hire them for less than 6 months, then your fee agreement with your customer stands. But it is against the law in Ontario to place a person on a temporary assignment that lasts longer than 6 months, or that ended in 6 months has passed, or some combination of the two from the beginning first day to 6 months later. If 6 months have passed from their first day with that customer, cannot charge them a fee. There's a whole bunch of links on the back page of your little workbook there where you've been scribbling down notes. You can write out those links. You can type on those links. You can just go to Google, type most of the stuff in. It'll get you to the right place. And you can find lots of resources in your province. And so please read them, go to them. And I am 3 minutes overdue. I am sorry. So guys, if you have any questions or answers, we are officially over. You will be checked off to have completed this course, and some of this stuff will be covered in your challenge exam. My email address, write it down there, is just send it to me personally, steve.jones at Bell, as in Bell Canada, BELL.net. steve.jones@bell.net. You can include Jennifer if you want to copy her on the question. Sometimes you send me a question and it's a really good question. So we want to answer that question and send the answer to everybody. So she'll monitor. We'll keep her included in those questions back and forth. If it's a private question, just send it to me and I'll take care of it for you. Please feel free to ask me any questions afterwards. And don't try to memorize everything in the Employment Standards Act. Just know what's covered in Employment Standards Acts. You'll do really well on the challenge exam, so don't kill yourself over that. And I will stay on the line for the next couple of minutes as long as you want. If there's questions coming in, unmute yourself and I will answer your question through audio. And or auditing isn't, it's 7 years. There's a question here for auditing isn't auditing 7 years. And the answer is for accounting for tax purposes, it's at least 7 years. For employment standards legislation, some things are 3, some things are 5. So if you're concerned about proving to Revenue Canada that you had a real expense, you got to keep it for 7 years. I'm not covering tax law. I'm just covering employment standards law. And so again, same thing. The answer is don't delete stuff too soon for a bunch of reasons. Again, if there's anyone on the line who wants to unmute, ask me a question. Okay, I think we're on tomorrow. Tomorrow's going to be a lot quicker. Is it tomorrow? I think we're on tomorrow. Tomorrow's going to be a lot quicker because the first bunch of slides are all very similar about the various levels of law, constitutional law. I'm going to bomb through that stuff really quickly. If there's people who come on tomorrow that missed today, I'm not going to waste your time by going over that a whole bunch. I'm going to make them go back and listen to this audio recording later on so they can pick up on that stuff. So tomorrow, hopefully we'll be done by about 3:30. That's exciting. If you can't offer people an interesting presentation, at least finish early. That's my philosophy anyways. Okay,
Steve,
so
if you have a minute, Steve,
Yep.
if you have a minute.
I do.
According to all the changes and new regulations and everything, is there a legislation that will legislate the rates in the industry?
No, absolutely not. So that's a really good question. Sorry, I got a fiddle, so I want to make sure I don't have an echo here. That's a really good question. It is against the law in Canada under what used to be called the Combines Investigation Act. Now it's called the Competition Act. It's against the law for competitors to collaborate together and share pricing. And it's against the law for an organization like ACSESS or anybody else to get together to create a collaborative to set pricing in the marketplaces. So anything like milk prices are all done with specific legislation allowing them to set the price for it. So there is and we talked about it today, legislation that sets costs. So minimum wage. unemployment insurance premiums, employers' health tax premiums, Canada pension plan, employer contributions, unemployment insurance. So there are mandatory requirements that establish minimum costs. But from then on in, it's up to all of us to figure out how we take our costs, control them, the ones that we legally have control over, and to figure out how efficiently we can operate and how we use those prices as part of our sales strategies or market strategies. But there is no provision in the law to set prices. Now, that doesn't stop a customer from going out there and issuing a contract saying, we pay $22 an hour, we pay $44 an hour. If you qualify, you can get on the bid, you can get on the list. So customers can set a rate that they wish people to receive, that they'll pay. We will not pay anything less more than $44 an hour. Here's the qualification criteria. If you qualify, you sign this thing that say you agree to $44 an hour. Customers can do that, but that's not. And so, I've had customers, especially in the home care business, that come up with contracts and I say, I'm not going to sign. That's stupid. I got lots of customers that are way better than that. I'm not going to use my resources to do that. And I walk away from it. So that's the only way that I know of that rates can be established in Canada legally. Any other questions? Let's take a look at this one that's here. How do I get access to the lectures? Okay, so Jennifer will answer that question for you. But this has been recorded and she will post it for a short period of time afterwards with a link for people. So it takes a day or two. They probably have to go and edit all my profanity. I don't know. But you will receive an email from ACSESS in the next little while saying, hey, for the next 2 weeks or something, this session that you attended is available for your review online. Good question. Okay, moving on. Thank you very much, guys. We'll see you again tomorrow. And again, we're going to be able to bomb through some stuff really quickly tomorrow because there's a little bit of duplication at the beginning, about access and about different parts of the law. So thank you very much. You've been a great audience. I really want you to interrupt me with more questions tomorrow so that I know that you're not sleeping, but either way. Have a great evening, guys. We'll see you tomorrow. Bye.
Thank you. Bye-bye.
Thank you.